Your Honor, I just asked in the audience and got negative responses.
All right. Is it Latoya Walton? Latoya Walton? Okay. And have all of our domestic violence victims been brought up this morning? Do we know? Is there anybody here that's here for a domestic violence case? If so, please raise your hand. Okay. All right. Any input from the state?
We would ask that you do revoke the bond, Your Honor.
State, can you tell me if charges have been filed on these two cases that he's out on bond?
I can look, Your Honor.
Your Honor, I can tell you that the fleeing has been charged. We're in negotiations on that one. I think he has a status hearing coming up soon, a plea status. He's got an offer of a year of probation. The other case, the newer arrest, the drug-related one, has not been charged as of me looking at the clerk's system this morning.
Okay. I don't see that it has been either. So, yeah. All right, I'll take no action on that case. I'll make a decision here in a second on that case that he's out on bond. State, what's your input with regards to release on the battery domestic? Reviewed the affidavit, found probable cause.
Just ask to revoke the bond on the flee and elude.
I know, but my question is on the battery charge. Any input with regard to release on the battery charge?
No contact, Your Honor.
Okay. Anything from the defense?
No, Your Honor.
All right. Do we have a sheet for him? Face sheets for him?
Oh,
Do we have our histories?
at the trade? Oh, maybe.
State, what's his history?
Two felonies, 5 misdemeanors, 2 FTAs, 9 unknown.
Are those convictions or are those just arrests?
Those are convictions.
Do you know how recent the last one was?
It was March of 2017.
Okay.
2017, Your Honor.
All right. Set his bond at $500. No contact, no return, maintain separate residence, do not possess any guns, knives, or weapons. What was his bond set at on the fleeing? Is it $1,700? $2,500? I'm going to revoke his release in that case. I'll issue a new bond of $3,500 for him.
Thank you, Judge.
Thank you.
And Your Honor, no action on the uncharged.
Yeah, I already said that. Yep.
Thank you, Judge.
All right, thank you. 500, no contact, no return, maintain separate residence, no guns, no knives, no weapons, and then the 2020 case, no action, and the 19 case, revoke and set a new bond of $3,500. So they're in BRC 2. And where's the PD at? Her office? Yes. Why does this thing keep saying mute? Even hit it, touch it.
Okay, I'm muted on that. On this thing? I don't know.
Oh. Let me look at these instructions. that new?
Yes.
Can the PD hear me? Miss Fowler? Okay. I'm going to hang up and follow these directions again. Call. BRC1. Call. Call connect to BRC1. And then it says select BRC2, so
I don't
that's
see
a
it
problem,
on there.
and there's no BRC2. Release center. I don't know, maybe that's it. Already in call. We'll call BRC. Once connected, press merge. It'll merge the calls, and you are all set.
You already have that, that's it.
Right. Already in call. If you need interpreting, interpret. Hang up, press and call. So I've done this is my third time. Calling and interpreting.
I can interpret and see what happens.
This is the worries with that. Miss Fowler, can you hear me?
Okay, so we can't hear the PD. She's on the screen, but we can't hear her.
Can't hear me.
She can't hear him. And then in courtroom two, they can't
I'm
see
in
the
court
judge.
now, but everything worked out. Thank you.
They can hear him, but they can't see him. Right, but he can see them. Right.
Call.
Well, he just, yeah.
BRC. Call.
It says disconnected, but everybody's still up there with. Yeah. Right.
Your Honor,
Yes.
at the angle you got the camera now,
Uh-huh.
we can see what you're wearing.
What's wrong with that?
Nothing.
How's my hair look?
I think they said they can see him now. They can see you?
So you can see and hear me?
No, I can see the lower part of it.
What you think?
I don't know, say it
You
again?
can see the lower part of it.
Lower part of me, where's the camera?
You said the camera's facing from mid-chest up, but they said they can see the lower part.
Blue and blue.
All I see is my face.
And some flip-flops.
No, but they said they see his lower part, so they must be seeing the.
That's a lie, somebody's feeding her information.
Early just turned,
Yeah.
I can tell you what you're doing. Early just turned around and looked at us. Now, we can only see the public defender. We can see her, but we can't hear her.
This is amazing.
They're not looking at the camera that's on his monitor. They're looking at the camera that's in the courtroom. Right. Right. His lower body.
I just want to know where this camera is. Is it under the table?
It's that one.
Oh, I see it panning over now.
So, defender, 'cause she can't hear her. She can't hear him either.
You need to go.
Oh, God. Oh, well,
On the,
You know how to work this thing? Yeah. No one does.
on the.
you know, he's apparently,
For this game?
I don't know who the IT people is.
Go on.
He didn't give us any information.
I'm on
Contact
hold with
them.
the IT people, or AB.
Who can try to call you? But we can't even tell her that she can't be heard. She don't know,
Yeah,
she's
so it
just
must be
sitting there
that.
looking, waiting for us
So
to
this is-
contact
Yeah,
them,
so this is what
but
you're seeing right
I
here,
guess
Pop.
for her to be on leave, I guess she don't know that she having a
Right,
problem.
see, this is what I thought we were seeing.
You understand?
I don't know.
No one knows.
Okay, yeah, do that, do that.
So do we know why? Okay.
He's gonna try to disconnect her and then see if she can reconnect
Once we get
on her own.
Yeah. How did yesterday was it? No?
But she didn't have a picture either.
See, that's what we see.
Okay. Thank you. Hey, there's somebody.
Judge, this is Paul with the AV department. Can you hear me?
Yeah, do you want me to hang up on you, or?
No, sir. I was just making sure to test the connection to make sure that it was the public defender or if it was us.
Okay.
So I just wanted to test. And I will hang up now.
He's on the phone. Here's something now. You can hear her tapping on the,
Yeah, we can hear her.
oh, she can hear.
Does anybody have a phone number for the public defender? She
That's
must
what
be
he
on,
was
but she
asking.
can't hear us though. Yeah.
I just sent her email.
You sent her a message?
Yeah. She said she can't hear anything.
Yes.
Right, we can hear her.
Oh, she went
She
on.
just left the call.
Somebody who's on there, you brought somebody on the bench, they get a copy of the charge.
Well, I'm trying to add the interpreter, they didn't have a
Yeah, and they're still on the line
They
too.
can't, they can't hear, even though it was a serious question.
Oh, they can't hear. Well, got the screen like that, they should have had the face.
It's been,
Under the handle. This shit got a hole in it, y'all. See? No,
You might well have.
just one.
No, that was- Okay. Yeah, he,
We still had this yesterday, it was completely blank.
Yeah.
So completely blank, first
This is slow me down. I'm like, walk 12.
you still don't go,
mm-hmm.
for this, once they get together, you know.
Welcome to an Acano meeting. You are entering the meeting now.
He said it must be on their end, so he gotta try to call their IT people. That's not who came up. It's not him.
You got the wrong one. Thing.
I was like, she was doing
She crazy.
she got up and like. She got me killed.
She at home?
He heard some kids, so maybe that was someone else.
Well, she ain't got no kids, she ought to be rich. But the kids break ya.
Not if you go. When I was single, just because I ain't had no kids.
I'm saying just right here today.
I was both as a joke.
Oh,
Yeah, I'm saying.
I know
You
this.
young, man, when you got there, when they take all that.
But whatever, I had death in the family.
I was different, man.
I was still going to I was still going. You get that before a certain time, you get them free. And then you get them more. So that's how I take the kids. I just had to like oh, that's
Not one.
Oh, that's, I know that,
Oh,
I'ma take the fifth. Oh, goodness.
Crazy.
Oh, you had to.
Maybe it's an issue on your end.
Yeah.
You talking about bring them all in.
All right, so what can we do without her? Is there anything we can do without
Talking
her?
about, could you bring three? No, one there, one to the corner.
No.
Now we can kind of pre-do these and then we'll run it by her when we get her.
Oh, yeah.
So state on the 33-day motions. What's today's date, the 26th? 5th. Blair,
Put a officer inside.
20 CF 6410. And then we'll just go over these again with her when we get her back.
Okay, so there are two Blair cases. Which one is it?
20 CF 6410.
On June 24th, there's a notice of non-filing.
Alright, so that'll be granted. Blair, 5587.
On June 9th, there was a notice of non-filing.
All right, that'll be granted. Fernandez, 20 CF 6277 AO.
On that one, I have clock copies. An information and request for administrative transfer was filed on June 24th.
Okay. Pryor, 20 CF 6475 AO.
On June 24th, there was a notice of non-filing.
Okay. And then I got another Blair, 5630 AO.
Yes, Your Honor, on June 24th, an information was filed, filing ID 109358883.
All right, that'll be denied. Douglas, 20 MM 3522 AO.
Yes, Your Honor, on June 24th, an information was filed, filing ID 109360073.
That'll be denied. Douglas, 3521.
Is that 35?
James Douglas, 20 MM 3521.
I have 3522. Is mine a typo?
I'm not sure. Maybe he's got two cases.
He's in on a 3522 and a 3521.
Yeah, I did 3522 already, denied. He said information was filed. And then 3521. Got somebody new on the phone.
Oh, that's a PD.
Yes, Your Honor, this is Ari Custom
Okay.
from the Public Defender's Office. Can you hear me?
I can. Can you hear me?
Yes, I was able to hear Miss Fowler earlier because I was on before and then somebody asked me to go do something else. But I'm on now and I can hear you and I can talk. She was going to re-sign on and see if it would work.
Okay.
If it doesn't, then I can do it.
See her, she just couldn't hear us.
Oh, she couldn't hear you.
Yeah.
Okay, that's weird.
All right, state 2-1.
Okay, Your Honor, back to those. On those two cases, I misunderstood the number on the first one.
Okay.
On James Douglas 20 MM 3521, an information was filed, filing ID 109360073. And then on James Douglas 20 MM 3522, on June 24th, there was a no information notice.
All right, so 2-2 granted, 2-1 denied.
Could you ask them in two if they can see you?
I don't care if they can see as long as we can hear.
Oh, you don't care they can see you?
I just want to know that we can communicate.
Okay. If he say he good.
Conception, 20 CF 6454 AO.
On that one, a filing is underway right now, Your Honor.
So nothing's been filed yet?
No?
Okay. Campbell, 220 CF 5843 AO.
Yes, Your Honor, on June 23rd, an information was filed, filing ID 109330675.
All right, Negron, 20 CF 6223 AO.
On June 24th, there was a notice of non-filing.
Okay. And Gerbert Static, 20 CF 5973 AO.
Yes, Your Honor, on June 24th, an information was filed, filing ID 109361387.
All right, we'll just go back over those when we get the PD. All right, do we have a public defender? He's gone. She's gone. Can't wait to see what happens. We're trying to get the interpreter on.
It's coming a little bit later. The first
That's gonna mess it up. When they try to.
And then these move ups are starting with the Spanish?
Spanish, yeah.
Okay.
Did you call them? They never did. Merge them in?
Jerk.
Well, let's, we're looking at the ceiling of the public defender's office. She ran away.
That's what she did.
I don't know what she is.
She said she don't want to.
Man, I had enough time to go put my suit and robe on for this. I would have gone back to my chambers and put that on, but I didn't realize we were going to be fooling around with this for so long. Okay. Would you prefer that I go put my robe on or just get this going since we're 35 minutes late? Okay. I'll do that for you guys.
Okay, thank you.
This guy? That's AV. That's the computer guy. I think it says orange and oh no, that's interpreter. Can our interpreter hear us? I think he can. Oh, but we can't hear him.
I didn't see him without the mask on. I don't know what he looked like behind that mask. Oh, we ain't got no PD.
I love coming out here and seeing you guys. I love when they need help that I volunteer to come out and see you guys.
We love you too to come out here, Your Honor.
I still love you. Still love everybody.
Are you gonna come back?
I don't think I'm ever leaving at this point. We're getting a tour of the PD's office right now.
Yeah.
No idea.
Is she white?
Can't hear nobody. We can't hear the interpreter?
Oh, I hear somebody.
Oh. They're still muted? Both of them are muted? The interpreter and the PD.
Your Honor, I will conduct the hearings until we can get it working.
Okay. So I've got you then and your name for the record.
Ari Kustin, Kustin.
All right. And I think our interpreter can hear us and see us.
I can hear you, Your Honor.
Oh, we hear you now.
Oh, okay.
All right.
Great.
Wonderful. And an appearance from the state?
Elaine Fusco, State Attorney's Office.
All right. And typically the public defender's office, at least the 2 years that I was out here and when I've covered, I've asked you to provide me with just a list of names that you have PC challenges on. And then I can, that way when we get to those cases, it'll make things a little quicker. Do you have any PC challenges that you want to give me the names for now?
Your Honor, I'm not sure because I didn't work it up. Let me get Letitia to me and I'll let you know.
How long is that going to take? Okay. All right, Mr. Interpreter, your name for the record?
Alan Figueroa, State Certified Spanish Code Interpreter, Your Honor. And Your Honor,
have you been
now that
sworn
you
in?
can, yes, Your Honor. Just a quick comment. Now that you can hear me, I tried to explain to you later. The reason why the public defender might have not been able to hear you is because if you look at the screen there in front of you where you see my face, down on the right, you see that little red light that has a mic with a line through it. That means you're on mute.
But everybody else can hear me.
Because we hear you through the speakers in the courtroom. Never mind. Worth the shot.
Well, no. I mean, I don't know what happened there. We'll try it. We'll see what happens. All right. And so you have been sworn in, correct?
Yes, Your Honor.
Okay. All right. And if you could interpret everything from this point forward. Your name, sir?
Luis.
Your last name?
Marcial Herrera.
You are here in case number 20 CF 7804AO, one count of tampering with a witness to hinder communication to a law enforcement officer, one count of stalking domestic, and 1 count of battery domestic. Were you interested? Is everybody just getting the public defender? Okay. I reviewed the affidavit, found probable cause, appoint the public defender. Any contact with the alleged victim?
No, Your Honor.
Any input from the state with regards to release?
No contact, Your Honor. No weapons or firearms. Separate residence.
Any input from the defense?
No, Your Honor.
All right. All right, his history looks, does he have a hold?
No, he was in on another charge, but he has been time served.
Okay. All right, I'll set count 1 at $1,000, count 2 at $100, count 3 at $100, no contact with the alleged victim, no return to the scene, maintain separate residence, do not possess any guns, knives, or weapons. Thank you. Did we separate out the Spanish sheets, or are they just mixed in? Yeah. No, I got it. Just take me a second to get your name, sir?
Jose Alonso.
Jose Alonso.
You are here, what's this one? This is misdemeanor? Okay. You are here in case number 20 CF 7798, 1 count of aggravated assault with a deadly weapon. Reviewed the affidavit, found probable cause, appoint the public defender. Set your bond at, now where would he be in this section? $1,000, no contact with the alleged victim, no return to the scene, do not possess any guns, knives, or weapons.
Okay, una pregunta.
I have a question.
Yeah, talk to your public defender, or does our public defender want to give him any advice, or just let him talk?
Your Honor, we advise him to not speak about the case at all. If he has questions about police conditions, for example, if he lived at the same location, we just request a one-time return. And then if he does have follow-up questions, to call the number on the sheet that he's going to be provided to him.
So, you want me to let him ask the question, or tell him to talk to you?
I believe he can hear me. Do you have any questions about the release conditions?
No, solamente lo que quiero decirle es que yo vivo ahí, la muchacha no vive ahí.
No, the only thing I wanted to say is that I live there. The lady doesn't live there.
Okay, then, Your Honor, we just asked the order say maintain separate residence, not that he can't return.
All right. I'm going to keep the maintain separate residence. I'm also going to keep no return to the scene. But you can return once with the assistance of law enforcement to retrieve your belongings. If they determine that she does not live there, then you can stay there.
Perfect.
Thank you. So is this the whole day or just the morning? All this? All, I don't know, I'm asking you, is this the whole day or just the morning? That's the whole day. Okay. Your name, sir?
Carlos Jose Carvajal.
Carlos Jose Carvajal.
You are here in case number 2020 CF 5834 on a violation of conditional release on one count of felony battery. According to this warrant, your bond is set at no bond. I will appoint the public defender to represent you if they haven't already been appointed. Thank you.
Don't we have a violation of pretrial release on Mr. Carvajal?
That's what I just read.
Okay, can we ask to have his release revoked in the underlying case?
¿Le puedo hacer una pregunta?
Can I ask something?
Your Honor, at this point, we ask that he does not speak at all.
State, all I have is a violation of release. Does he have a new law offense?
Just the violation of the conditional
No, no
release.
tengo ninguno. Yo puse los 500 de fianza. ¿Puedo salir? Porque yo puse los 500 de fianza. Fui a la cita que me mandaron a la corte. Me volvieron a tener aquí 3 veces por el mismo caso. Yo me mudé, no pasó nada. Y me han pasado 3 veces aquí.
He's pleading his case.
No,
Por
I
favor.
haven't violated anything. I paid the $500. I came to court the 3 times. I've been here 3 times already. All I did was move. Nothing happened. I've already been here 3 times.
Okay.
Your Honor, at this time, we just ask that he call his lawyer if he has any questions.
Okay. Thank you.
Gracias.
Your name, sir?
José Hernán Osorio. Hernán Osorio.
Jose Hernan Osorio.
You are here in case number 2020 CF 66510 on one count of lewd or lascivious molestation with a victim under the age of 12 and one count of solicitation to commit sexual battery. This is via arrest warrant. According to this warrant, your bond is set at no bond as to each count, with conditions no contact with the alleged victim. I will appoint the office of the public defender to represent you. State any input with regards to release.
No contact with any minors under the age of 18, Your Honor.
And with regards to
And-
bond, count 1 is a capital offense, count 2 is a F1.
We ask the court to consider all the facts in the affidavit, including the victim's statement and the statement by the mother regarding her confrontation with the defendant, to find proof evident or presumption grade and hold him at no bond.
Any input from the defense?
Your Honor, we leave that at the court's discretion. Also, I just want to make sure he understands to not say anything right now about the case, and that he will get the lawyer's phone number. So just to not ask any questions right now at all, and we will explain if he has some follow-up questions.
Okay. All right, sir. I have reviewed the affidavit in support of the arrest warrant. I do find proof evident presumption great. I will stay your bonds at no bond. The conditions of your release will be no contact with the alleged victim, the alleged victim's family, and no unsupervised contact with any minors. I've appointed a lawyer, sir. Make sure you talk to your lawyer. I've reviewed your history, and I believe that you might be entitled to a bond when you get a full and fair bond hearing. Thank you.
He also has an immigration hold, Your Honor.
Okay. You also have a hold for immigration. Oh, yeah. So even if you do get a bond in this matter, until that hold is cleared, you may not be released.
Okay.
Thank you.
On count 1 and 2, presumption grade, on count 1 and 2, just count 1.
Count 1. You know what? Set his bond at $25,000 on count 2. Madam PD, I'm going to give him a $25,000 bond on count 2. He's entitled to a bond on that case, and then if count 1 doesn't go forward, he'll have that $25,000 to bond out with. Your name, sir?
José Villavicencio.
Jose Villavicencio.
Exacto, juez.
You are out on bond in 2020 CF 7389 criminal mischief at a place of worship, 2 counts. You're here today in 2020 CF 7467 AO, 1 count of arson of a structure, 1 count of attempted arson of a structure, and 1 count of an arson of a structure where persons are normally present. This is by arrest warrant. Your bond is set at $10,000 on count 1, $5,000 on 2, $5,000 on 3, for a total of $20,000. Conditions are no return to Calviro Church. It looks like this occurred prior to your case that you're out on bond. So I'll take no action on that case. I'll appoint the public defender on the new case. I'll set your bond on count 1 at $15,000, count 2 at $150, and count 3 at $150. Thank you.
What was his last name again?
The last felony.
Is that all our Spanish?
Yes.
And so the only interpreter case that we have left is a sign interpreter?
Yes.
Okay. All right. Thank you, Mr. Interpreter.
Not a problem, Your Honor.
Have a good one.
You as well.
You found it?
Yeah. I know I looked at it. I forgot to pull it out. All right, Queen, are we ready to go? Miss Taylor,
Oh, yes, Your Honor.
are we ready?
Yes, we are, Your Honor.
All right. Your name, sir?
Your Honor, the first person on the docket, Jason Clavet, medical.
Yes.
Medical.
Okay. All right. 2020 CF 7792 AO. Appoint the public defender. Do you want to waive him or roll him?
Yes, Your Honor, we're asking to waive, and we're asking that we will provide a no contact order if there is no victim in the
Is there anybody
gallery.
here for Jason Clavet? No? Okay. Any input from the state?
No contact, no weapons or firearms, separate residence, and also alcohol was a factor, asked for no alcohol.
Okay. Any input from the defense?
No, Your Honor.
All right, we'll set his bond at $500. No contact with the alleged victim, no return to the scene, maintain separate residence, do not possess any guns, knives, or weapons, and do not possess or consume any alcohol or illegal drugs. Thank you. Who do we have next?
Brenda House Claw.
Yes?
Medical.
All right, 2020 CF 7767 AO, temporarily appoint the public defender, waiver roll.
Wait.
All right, any input from the state?
Yes, Your Honor, no contact, and alcohol was also involved in this case, so no alcohol, and separate residence, no weapons or firearms.
Any input from the defense?
No, Your Honor.
All right, set his bond at, her bond, I believe, at $1,500, no contact, no return, maintain separate residence, do not possess any guns, knives, or weapons, do not possess or consume any alcohol or illegal drugs. All right, and who's next? James Moore?
Yes, Your Honor. Will not be attended due to his behavior.
Okay. 2020 CF 7791 AO, ag assault with a deadly weapon, temporarily appoint the public defender, waiver roll.
Waive.
All right, any input from the state?
He has a victim, Your Honor.
Okay, do we have somebody here for this? All right, and ma'am, are you Latheria Moore?
Right.
All right. Ma'am, you are listed as the alleged victim in this case. As the alleged victim, you're entitled to provide input with regards to conditions of release. Can you hear me?
Yes, I can.
Okay, I just wanted to make sure. So some of the things that we need to consider today is whether or not the defendant here should be released with having to post a bond or post some sort of non-monetary bond. If there is a bond, how much? Whether or not contact is appropriate, not appropriate, or some form of limited contact is appropriate. Whether or not alcohol or drugs are a problem. Whether or not if you live together, if you should maintain a separate residence. There are a lot of conditions. Every case is different, and so typically the conditions will vary as well. As the alleged victim, you're entitled to tell me anything you think I need to consider in making those determinations. Is there anything that you want to tell me?
Yes, I would like to have him because he's on drugs and makes threats. He never touched me, but he makes threats. And I have grandkids in the house, and he uses foul language. He calls me all kind of curse words. And it's just scary. I mean, he goes out, he come in at 3 and 4 o'clock in the morning. Instead of him ringing the doorbell, he beat on my window like he gonna break it. And, it just been going on for a while. I had asked the court once to please get him some help. He need help.
Okay. All right, State, do you have any questions for her?
Nothing further, Your Honor. We just asked for no contact, no weapons or firearms, no drugs or alcohol. And since he has 10 felonies, 11 misdemeanors, 2 FTAs, and doesn't qualify for PTR, we asked the court to set bond, stay the bond.
Well, I don't think I could stay at 0.
Oh, mine sheet says 1,500.
Oh, well, it's apparently domestic, so that's why I got corrected to 0. So 1,500 is the suggestion of the state?
Yes, Your Honor.
Okay. Any input from the defense? Defense, any questions for her?
No questions. We are okay with a $1,500 bond.
Okay. All right, and you guys live together?
Yeah.
And do you want him to come home, or do you want him to maintain a separate residence?
I'd rather have separate residence, but he don't even work. I don't know.
Okay. Well, we care, a lot about you, so we want to make sure that you're comfortable with the conditions of release.
Well, I just, it's just an uphill battle. He'll tell me, he's not going to do this, and he, apologize and stuff, but then he gets back out there, with this crowd, and he's in the same state he was in before.
Okay. All
Every
right.
time I give him another
He
chance.
asked for separate residence, Your Honor, with a one-time return.
What's his financial ability?
He don't have one.
Okay. All right. I'll reduce his bond to $750. I'm going to order no contact, maintain a separate residence, no return to the scene. He can return once with the assistance of law enforcement to get any kind of belongings. Okay? And he'll be subjected to RUAs through PTR as a condition of his release. So I reduced his bond due to the financial issues, but I've read the facts of the case, I've looked at his history, and I'm going to require him to have random drug tests. So as long as he stays off drugs, he'll be okay. But if he's doing drugs, because you're saying when he's high on drugs he threatens you, then we'll pick him back up, okay?
Okay.
Is there anything else?
No, that's it.
All right, do not possess any guns, knives, or weapons, if I didn't say that. All right, thank you for being here, ma'am.
Thank you.
Your name, sir?
Sharon.
I'm sorry, one more time?
Courtney Sharon.
Okay. All right, 2020 CF 6898 AO, one kind of aggravated battery, domestic, and 16 CF 5861 AO, violation of probation. The domestic violence is via arrest warrant. The bond on that is set at no bond. The violation of probation is via warrant. The bond on that is set at no bond. I'll appoint the public defender on each one of your cases. I know. I haven't gotten there yet. I'm almost there. I'll appoint the public defender on both of your cases. Ma'am, your name?
L'Oreal Johnson.
Okay. Were you able to hear the discussion that I had with the lady that was there before you?
Yes.
Is there anything that you want to tell me? Anything you think I should consider?
Courtney and I are engaged and we live together. I'm not sure if I will have to speak with the state attorney's office about the police call. The physical injuries that I endured were self-inflicted. At that time, I had just had a miscarriage and was suffering depression. And as you stated, Courtney has a VOP. He was trying to leave the home because we were arguing because of his violation of probation. And I thought that by harming myself, he was going to stay home and try to work things out. And when I caused the injuries, he just fled, and I needed medical assistance, so I called the police. He is able to return home. He's the sole provider. I've been out of work for 4 months from a work-related injury, so financially, he provides for myself and my children. Other than that, I know he has to deal with the violation of probation, but I know I have to reach out to the state attorney's office, as I've already emailed them and tried contacting them as to what will happen to me because of the statement that was made to the police, but I never did a written statement. I just needed medical attention, so I told them that I was harmed.
It looks like he's on probation for aggravated child abuse.
Yeah.
Is that a child that lives in the home as well?
No.
Okay. All right. All right, State, do you have any questions for her?
Yes, how long have you been together?
8 months.
And has anything like this happened before?
No, as I mentioned to the responding officers, that was our first argument. Within that first week, we had been arguing. I think it was due to me miscarrying, but we had never been into any arguments or anything in this nature.
Since he has a history of aggravated battery and the aggravated child abuse, Your Honor, we would ask for no contact in separate residence.
Defense, do you have any questions for her?
Yes, Your Honor. Ma'am, are you saying that you falsely accused my client of something that didn't happen?
Yes, ma'am, but I thought because I didn't write a statement that nothing would be pursued, that I would just get medical attention and then all of this would be over.
Okay, and you're not in fear if you were to come home?
No, we've been living with each other since, and we haven't had any issues.
Do you know if a monetary bond given, would you be paying that bond?
Yes, ma'am.
No further questions, Your Honor.
Any input from the defense?
Yes, Your Honor. We're asking for PTR and his bond not be revoked. The witness just stated that he lied about what he said to the police. We're asking for no hostile contact. Nothing further.
Well, his bond's not revoked on his other case. He's on probation, and a violation of probation warrant was issued at no bond from Judge Roche. So I'm not inclined to change that.
He also doesn't qualify for PTR, Your Honor. He's a violent offender of special concern.
Okay. All right.
Yes, Your Honor. I was just asking for it to be imposed by the court due to the testimony.
Sure. Okay. All right, ma'am, I know you said you were out of work. Does he have a job?
He's supposed to start he was working as of last Friday. He's supposed to start a new job on, I believe, July 1st at a different 7-Eleven. So that's another reason why, he needs to be out to be able to continue to provide.
Okay. All right. On his violation of probation, it's set at no bond, and there's nothing that I can do about that.
Right.
You're going to have to talk to the state and talk to the judge in that case. On his aggravated battery, I'll set his bond at $750. All right, so I cut it in half for him. No hostile contact. No hostile contact means no physical abuse, mental abuse, verbal abuse, emotional abuse, things that we should all be doing anyways.
Right.
Do not possess any guns, knives, or weapons. Do you have any questions, ma'am?
No, sir.
Okay, thank you for being here.
Thank you.
All right. Do we have Cardona next? Do we have any more victims? No? All right, thank you. You guys are too fast for me. You're getting ahead of me, which is unusual. Your name, sir?
Jaime Cardona.
I'm going to speed it up. What, I'm sorry, what is it?
Jaime Cardona.
Okay, I'm sorry. 2020 MM 46560, battery, domestic violence. Review the affidavit, found probable cause, appoint the public defender. Any contact with the alleged victim?
Yes, Your Honor, she will not attend.
All right, any input from the state?
No contact, separate residence, no weapons or firearms.
Any input from the defense?
No, Your Honor, we just asked a reasonable bond be set.
All right. I'll set his bond at $500.
He does
No
qualify
contact
for
with the alleged.
He qualified for PTR.
Okay. State, what's the state's position on PTR without victim input? Hey, what's today's date? 25th.
Agree to PTR.
I'm sorry?
Agree to PTR.
All right. I know, Mr. Cardona, this is probably not the birthday that you expected. I'll set your bond at $500. In the alternative, if you want to be released through the pretrial release program, you can pick the pretrial release program. That may have been explained to you, maybe not. Either way, the conditions are no contact with the alleged victim, no return to the scene, maintain separate residence. Do you need to go back for any reason?
I need to pick up my clothes and my stuff.
Okay. You can return once with the assistance of law enforcement to retrieve your belongings, okay?
Yes, Your Honor.
And you don't have to make a decision right this second if you want to post the bond or the PTR, but at some point when you decide that you want to get out, you just have to let the jail know if you want the PTR or if you want to post the bond.
Okay, what's the PTR?
It's similar to a probation. You'll be released. You'll have to, is it phone in now with everything that's going on, even on the batteries?
Yes.
Okay, you'd have to phone in once a month, make sure you stay out of trouble, make sure that you're following the conditions of release. The difference is you just don't have to pay any money to get out.
Yes, sir. Thank you.
Okay.
I'll choose that one.
Okay, thank you.
Your Honor, you gonna leave it at PTR or
He says he's taking PTR.
so straight PTR?
PTR. Thank you.
We have the
Your
signed
name?
interpreter, Your Honor.
Okay. I thought I saw her. Should you go straight to your courtroom?
I didn't know that she was coming, wasn't gonna come inside, so I sent her to the other one to let her in, but we ended up over there.
Okay. All right. And then we have the interpreter in the courtroom.
In the witness box, Your Honor.
Okay. And your name for the record?
Julie Balassa, nationally certified interpreter.
And have you been sworn in?
I have not.
Can you raise your right hand for me?
Raised.
Do you swear to interpret from English to American Sign Language and American Sign Language to English to the best of your ability, so help you God?
I do.
All right. And your name, sir?
Tyrone.
He didn't hear you.
Tyrone Thompson.
You're here in case number 2020 MM 3830, trespass on property. 2020 MM 3170, trespass in an occupied structure. You're here today in 20 MO 735 on a violation of a state misdemeanor for trespassing from Lake Eola Park. I reviewed that affidavit, found probable cause, appoint the public defender. I will ROR you or release you without having to post a bond. I'll take no action on the cases that you're out on bond. State, is there an offer to resolve this case today?
Yes, Your Honor. The offer is adjudication of guilt, credit for time served, court cost, no return to the scene of the trespass at Lake Eola Park.
Defense, do you want to talk to your client, or do you want me to ask him if he wants to accept the offer?
Your Honor, you can ask him if he'd like to accept the offer. There's no reason why he shouldn't from just my quick search, unless he's on probation. And if he does want to accept it, you do not need to appoint us for him to pay.
Oh, okay.
Where is the lawyer? Because where is my lawyer? Because I was already in court.
Sir, the offer in your case is an adjudication of guilt, credit time served, no return to Lake Eola Park. I will waive your costs so you don't have to pay that. If you want to talk to a lawyer, it will cost you $40 to talk to a lawyer. Do you want to accept this offer or talk to a lawyer before you make a decision? Why are there so many sticky notes, highlighters?
Little communication difficulties, Your Honor. One moment, please.
Okay. Who uses it? This used to be my desk. I can't.
Shelter? There were bugs? Well, the responses are not responsive, Your Honor. I can't get an answer as to whether he accepts.
I've reviewed his face sheet. It appears as though he has a history of mental health issues. So I'm not inclined at this point in time to accept any plea. He is ROR. I'll appoint the public defender. Make sure you stay in touch with your lawyers, sir.
I already have copies of paperwork from lawyers. Yes, but today's different. You have to discuss with a lawyer. Today's different. Okay.
Thank you.
Call the lawyer, okay. Thank you, Your Honor.
Have a good day.
You too.
Did Johnson make this mess? Oh, no, done with this. All right, this does not look like Claudia Castro Herrera.
No, Your Honor, she will not be attended due to medical.
2020 MM 4653 AO, temporarily appoint the public defender, waiver role.
Waive, Your Honor.
All right, appoint the public defender, review the affidavit, any input from the state?
No contact, separate residence, no weapons or firearms, Your Honor.
Any input from the defense?
No, Your Honor.
All right, set our bond at $250, no contact, no return, maintain separate residence, do not possess any guns, knives, or weapons. Is this Ronald Gilliland?
Yes, sir.
All right. You're here in 2020 MM 4654AO, one count of battery, dating violence. Reviewed the affidavit, found probable cause, point to public defender. Any contact with the alleged victim?
No, Your Honor.
Any input from the state?
No contact, no weapons or firearms, separate residence.
He qualifies for PTR.
Yes, Your Honor.
Don't object.
Okay. Any input from the defense?
No, Your Honor, we just request PTR.
Okay. All right. I'll set his bond at $250 or pretrial release, whichever one he chooses. No contact with the alleged victim. No return to the scene. Maintain separate residence. Do not possess any guns, knives, or weapons. You understand, sir?
Yes, sir.
Do you want to take the PTR or the bond, or do you want to wait to make a decision?
I'll do the bond.
Okay. Thank you.
Thank you.
Mr.
He's taking.
Hart, do you understand that PTR just gets you released without paying the monetary bond? You would just have to report and they keep you informed of your court date?
Yes, ma'am.
Okay, thank you.
Okay.
You guys have had a conversation with everybody before court, right? Or we still
No,
doing
Your
it?
Honor.
Oh, no? Okay. I'll make sure to talk to him a little bit more about it.
Thank you.
Version. Yep. I know in the past you guys have met with everybody or had a conversation or.
As soon as we can, we'll start doing that again. Right now, we're very short staffed.
Yeah, same here. I got called in to cover today. All right, ma'am, your name?
Melissa Gray.
2020 MM 4647AO. You're here on one count of battery, domestic violence. Reviewed the affidavit. Found probable cause. Point the public defender. Any contact with the alleged victim? I don't have any contact.
No, Your Honor.
Any input from the state?
No contact, separate residence, no weapons or firearms.
All right. Any input from the defense?
No, Your Honor.
Set your bond at $250. No contact with the alleged victim. No return to the scene. Maintain separate residence.
What
Do
about
not
my
possess
kids?
any guns, knives, or weapons.
What about my kids?
All right, ma'am. When a defendant is here on a domestic violence case, the statute allows the court to impose certain conditions of release to make sure that the alleged victim and any other family members are in a safe place without the alleged victim here to testify that it's okay for you to return or to request some form of non-hostile contact. The court's inclined to keep the contact at no contact.
Yes, sir.
That being said, I've appointed a lawyer to represent you. Your lawyer can and will reach out and try and get that contact changed to something that's more amenable. But at this point in time, without any input, I'm going to order no
Your Honor,
contact.
can I have a question? I'm sorry.
Your Honor,
on,
before
hold
you
on.
speak,
Yeah.
may I say something?
Sure.
My husband was also charged. I'm sorry. He was also charged too with the same thing. The officer said he was charging us both, and I was going to be a victim, and he was going to be a victim. We're Jeffrey Gray, and he said that they were both. I was the only one that got arrested, but he said that we would both be charged. I'm sorry. I'm sorry.
I was saying I don't have Greg.
Your Honor, I'm sorry.
Go on. I'm sorry.
What some of the judges have been doing is just for demeanors is asking for a non-interested party if there's like a sister or a mom or something, just to communicate only for purposes of childcare. So we are requesting that at this time.
That was a longer narrative, yeah. All right. Who's the third party, ma'am?
It would be my the grandma.
I'm sorry. I'm sorry. I couldn't hear you.
I'm sorry. My mother-in-law.
Your mother-in-law?
Yes, ma'am. Yes,
State? Is that acceptable?
No objection, Your
Alleged
Honor.
victim's father. All right. You can have third-party contact through your mother-in-law. What is her name?
Kathy with a K. Kathy Gray.
And her last name?
Gray. Gray.
Okay. That contact can only be limited to the care and concern about the children.
Okay.
I'm also going to order do not possess or consume any alcohol or illegal drugs.
Got it.
Do you understand?
Yes, sir.
Okay, thank you. Thank you, State Defense. What case is she here?
Oh, I'm sorry, that is Wellington, Demetra.
Okay. All right, sir, your name?
Hart.
All right, sir, 2020 MM 4652AO, one count of battery, dating violence. Reviewed the affidavit, found probable cause, point the public defender, any contact with the alleged victim?
Will not attend. Will not attend.
All right. State, any input?
No contact, separate residence, no weapons or firearms.
Defense?
No, Your Honor.
All right, we'll set your bond at $500, no contact with the alleged victim, no return to the scene, maintain separate residence, do not possess any guns, knives, or weapons.
He did qualify for PTR.
Oh, he does? I don't have that on mine.
Marvin Hart.
Yeah, Marvin Hart.
Yes.
Okay. Sir, you also qualify for pretrial release.
Yes, sir.
Has that ever been explained to you?
Yes, yes, I have. They have. I've been there, but I haven't got it thoroughly explained to me. But I would love to have that done.
So do you want to do pretrial release then?
Yes, I do.
Okay. All right, I'll give you a pretrial release with the same conditions.
Okay.
All right, thank you.
Thank you, Your Honor.
Your name, ma'am?
Your Honor, Tangela Scott will not be coming to court due to medical.
Okay. 2020 MM 4642AO, temporarily appoint the public defender, waiver role.
Waive, Your Honor.
All right, any input from the state?
Yes, Your Honor. No contact, separate residence, no weapons or firearms.
Is that the victim for her?
And I thought this was here for Demetra Willingham, right? We're two more, and then we're there.
Oh.
Or I'm sorry, well, the next one after this one. I'm sorry. Any input from the defense?
No, Your Honor.
All right. Set her bond at $500. No contact with the alleged victim. No return to the scene. Maintain separate residence. Do not possess any guns, knives, or weapons. All right, ma'am, your name?
Denitra Willingham.
All right, ma'am. You were here in 2020 MM 4641AO on one count of battery, dating violence. And then, ma'am, your name?
Robin Walker.
Okay. And then you just showed up, right?
Yes.
Okay. So you weren't here when any of the other alleged victims spoke, is that correct?
Yes.
Okay. You were not here?
No, I wasn't
Okay.
here. I wasn't here.
All right. Ma'am, you were listed as the alleged victim in this case. As the alleged victim, you're entitled to provide input with regards to conditions of her release. So some of the things that we need to determine is whether or not she should have to post a monetary bond, and if so, how much that bond should be. Whether or not contact is appropriate, not appropriate, or some form of limited contact is appropriate. Whether or not drugs or alcohol are a problem, any number of things. Everybody's case is different. So that being said, is there anything that you want to tell me, anything you think I should consider in making those decisions?
No, I want contact. I want her home. No alcohol or drug problem. No problems.
Okay. State, do you have any questions for her?
How long have you been together?
A little over 3 years.
And
Oh.
have there been 2 prior arrests with you as the victim?
Yes, ma'am. Due to other callers.
Your Honor, we would ask for no contact based on the 2 prior arrests with the same victim.
Defense, do you have any questions for her?
Yes. With the
I'm sorry, man. There's an attorney that's on the screen, kind of in the middle bottom. She's going to ask you maybe she'll ask you some questions.
Yes. Do you know if she's ever had a conviction for domestic violence?
Do I know? No.
With you as victim?
Oh, yes, they called. She went to jail last time, but I told them the same thing. I want contact because I wasn't the one who called. We was arguing, and the outsider called the police and did a statement and everything, and they had to take.
So, I'm sorry, are you scared of her?
No, I'm not scared of her.
And if you felt you were scared in the future, you call the police?
Yes, I would.
Do you have any worry about her attending future cases?
No.
Nothing further, Your Honor. We request, if she doesn't qualify for pretrial release, court-ordered pretrial release due to the victim's statements, and we request no harm.
She also took out work blades and a mini bat, Your Honor.
Hold on one second.
She didn't qualify at the time of her interview.
What were we missing?
They were unable to verify her community ties.
With her here, can we do that?
If you want to court order her to pretrial release.
That's fine. Miss Willingham, I'm inclined to set your bond at $250 or release you through the pretrial release program. Has that been explained to you?
Yes, Your Honor. I would like to do the pretrial release.
Okay. All right. I'll give you pretrial release with conditions: no hostile contact with the alleged victim. No hostile contact means no physical abuse, mental abuse, emotional abuse, verbal abuse. Do not possess any guns, knives, or weapons. And then, ma'am, I think you asked for no alcohol or drugs. Is that correct?
No. I was saying that's not the problem. That's no problem.
Oh, it's not a problem.
Yeah, it's not a problem.
So she doesn't drink or do drugs?
No.
Okay. Sorry. I'm glad I asked. All right. Anything else? All right. Thank you.
No problem. Thank you.
Thank you for being here. All right. That's all our DV, correct? Yeah. Your name, sir?
Shaw Couch.
20 CT 3995 and 20 CT 3996 DUI and refusal to submit. Review the affidavit, found probable cause, point the public defender, set your bond at 500 on count 1, 100 on count 2. Do not possess or consume any alcohol or illegal drugs. You understand, sir?
I believe so.
I'm sorry?
My bond is $600?
Yes.
Okay. If I don't have $600, does that mean I'm gonna have to stay in jail?
Or use a bail bondsman or see if you can borrow it.
Okay.
All right, thank you. Your name, sir?
Tita Bunsen.
Right there. I'm sorry, your last name again?
Bunsen.
How do you spell that?
D-U-B-U-I-S-S.
Thank you. I'm sorry. It's the connection's not the clearest. 20 CT 470, AE 20 CT 471, AE 20 CT 472, AE attached tag not assigned, driving while license suspended, unregistered vehicle. You're out on bond on a Dwillis and possession of cocaine. State, have you filed charges on that?
I would have to look, Your Honor.
I'll set your bond at 100 on count 1. I'll ROR you on count 2, ROR you on count 3.
What is count 1 and what? Because mine doesn't.
Just give them a $100 bond on the Dwillis. That's what I have as count 1.
Okay.
And ROR on the registration and the tag. PC on all 3.
Okay.
I have the case hasn't been filed on the one that he's out on bond. I'll take no action on the case that he's out on bond.
On both cases?
I just have one. Oh, well, Dwillis in possession of cocaine, right?
Yeah.
Yeah. No action. Thank you.
Are we doing the arraignments next, Your Honor?
I've got
Okay, the first one on the docket, Anthony Alls,
yeah, PD 2020 CT 3837.
medical.
What do you want to do, PD?
Enter not guilty, please.
All right, enter not guilty plea, set him for PTC. You want that or throw it in the trash? All right, how about Emmanuel, put it on the record, come on.
Division 84, pretrial conference date July 23rd at 10 a.m. Courtroom 4B.
Ooh, thank you. How about Emmanuel Becerra Ruiz?
Medical, Your Honor.
2020 CT 492 AA. PD's been appointed. What do you want to do?
Not guilty.
All right, not guilty. Medical.
Division 81 pretrial conference, July 24th.
No, put him on the August 10th one. Or what's the
Oh.
next PTC?
I don't know, I only have this one.
Okay, fine, put it on that one.
July 24th at 9 a.m. courtroom 4E. What is it?
Right. And then we've already filled that pretrial up, that's why I wanted to put it on another, but we'll just add another one. All right. How about Esteban Rivera?
Medical, Your Honor.
All right, PD, 19mm 3384, arraignment, not guilty?
Yes, Your Honor, not guilty.
All right. Division 83.
Division 83 pretrial conference, July 7th at 8 a.m. courtroom 6D.
All right, who is this gentleman that's been patiently waiting to have his name called?
I think it's your, we got one more person before that.
Christy Cologne?
Mickens. Jermaine Mickens.
I don't have it.
His status here?
Status.
Status?
First one.
Is Menkins here?
Your Honor.
All right,
Medical.
per Judge Blue, bond to be modified at $2,000 cash or surety.
And this one is a plea hearing.
All right, I think that's my plea, right? What's your name?
David Wallace.
All right, sir. Can you raise your right hand for me?
Yes, sir.
You swear to tell the truth, the whole truth, nothing but the truth, so help you God?
Yes, yes, sir.
All right, you can put your hand down. My understanding is you got 196 days in. We're going to give you credit time served, get you out of here.
Yes, sir.
Okay. I don't know why we kept you in here for 196 days, but we're going to get you out on this case. I don't know if there's anything else holding you up.
He does have a felony case.
Okay. You understand that by resolving this case, we're not going to go to trial?
Yes, sir.
You're not under the influence of drugs or alcohol?
No, sir.
If you're not a U.S. citizen, you could be deported for this. Do you understand?
Yes, sir.
And if you've ever been convicted of a sexually violent or sexually motivated offense by entering this plea today, it could subject you to involuntary civil confinement. Do you understand that?
Yes, sir.
Guilty or no contest?
No contest.
All right, 19 MM10017AO, accept your no contest plea, adjudicate you guilty, sentence you to 196 days with credit for 196. I'll waive your costs. It's the least I can do for you, okay?
Okay, thank you, sir.
30 days to appeal. Good luck.
Yes, sir.
So are we to Christy Cologne now? No? Yeah. I've got Algie Alexander bonded out. There was a status hearing on restitution, so that's it. I'm not doing that one.
Do you have an inmate number for Cologne?
I don't have that name on my
Christy
it's
Cologne?
a VOP. Misdemeanor VOP. Yes, he's not on our.
No, it's just
This
you.
is. Go ahead and address her, Your Honor. She's,
Okay.
medical.
Okay, Christy Cologne, out on bond 2020 MM1814AO, here today on a violation of probation 19 MM6681AO. Appoint the public defender waiver role. All right.
Wait.
The bond is set at no bond, and I'll take no action on the petty theft. All right, and then what's the deal with Augusta?
He refused.
All right. ROR on a trespass, 20 mm 3855AO. Here today on a petty theft, 20 mm 4649AO. Temporarily appoint the public defender. He's also here on 20 MO 732, injuring wildlife on a public property. Appoint the public defender. Do you want to waive him or roll him?
Thank you, Your Honor, and on his out on bond, there's been no information filed. We asked the bond not be revoked.
Okay. All right. I'll stay his bonds on the two new cases. And I'll take no action on the case that he's out on bond. All right, your name? Sir?
Heath.
What happened to Ronell Philpott? Or am I in the wrong section here? Heath? Is Heath your first name or your last name, sir?
Last name.
All right. What about Philpott and Soto?
What is it?
Okay. Soto is behavior, 20 MM 4651AO, exposure of sexual organs, resisting officer without violence, temporarily appoint the public defender, waive or roll.
What was the reason for his not coming?
Behavior.
Okay, if we could roll, he's resolvable.
Okay, we'll roll him to tomorrow. And how about Ronell Philpott? Inmate number is 200-14500.
We don't have him on our docket, Your Honor.
He bonded. All right, that brings us to Mr. Heath. 20 MO 733, disorderly conduct. Reviewed the affidavit, found probable cause. State, do you have an offer? All right, sir, if you want to resolve your case, it's adjudication of guilt and court costs, or you can walk out of here with your $100 bond. If you want to talk to a lawyer before you make a decision, it'll cost you $40. You want to resolve it, walk out of here with your bond, or have a lawyer appointed?
Want to resolve it?
Okay. All right, can you raise your right hand for me? Do you swear to tell the truth, the whole truth, nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can put your hand down. You understand by resolving this case today, I'm not going to give you a lawyer?
I do.
Are you under the influence of drugs, alcohol, or medication?
No, Your Honor.
If you're not a U.S. citizen, you could be deported for this. Do you understand? Sir?
Yes, sir. Your Honor.
Do you understand that if you're not a U.S. citizen, you could be deported for this?
Yes, sir, Your Honor.
Okay. And if you've ever been convicted of a sexually violent or sexually motivated offense, by entering this plea today, it could subject you to involuntary civil confinement. Do you understand that?
Yes, Your Honor.
Pleading guilty or no contest?
Guilty.
Accept your guilty plea, adjudicate you guilty, sentence you to a day with credit for a day. I'll waive your costs. 30 days to appeal.
2 days.
Oh, 2 days. I'm sorry. Yeah, sentence you to 2 days with credit for 2 days. 30 days to appeal. Good luck.
So,
Yeah, came out to 17 something.
Your Honor.
Sorry? Yes?
Does that mean I go today?
Yes.
Okay.
Thank you.
Thank you.
Ray Lamar, see you around?
He refused, Your Honor.
He is?
Your Honor, we'd like to waive his appearance. He has a competency hearing.
Right. I know Mr. Lamar. I'll take no action on everything. He's out on bond. Find PC, appoint the PD, and ROR him on these cases.
Why he wasn't here?
They waived his appearance.
I can't go. What did he feel?
Oh,
Refused.
Mr. No. How about Divinard?
Medical.
2020 CF 7781AO, grand theft third degree, temporarily appoint, waiver roll.
Wait.
Reviewed the affidavit, found probable cause. Set his bond at $2,000. How about James Eckford?
That's the one that the state requested that Epford and Johnson be put to
the
last.
end? Okay. Eckford and Jackson, you said Corey Jackson?
Johnson.
Johnson, okay. So do we have Corey Jackson then?
We got Glenn. Sorry. Yeah.
And your name, sir?
Corey Jackson.
All right, 20 CF 7778 AO, burglary of a dwelling, criminal mischief. Reviewed the affidavit, found probable cause, appoint the public defender, and set your bond at $3,500 on count 1, $100 on count 2, no return to the scene. Thank you.
I have a bond now.
Yes.
These are add-on charges.
Thank you.
Well, he's got a bond on this one. What else did he have?
These are add-ons, so he has no bond on another case.
Oh, okay. All right, your name?
Hi, my name is Elizabeth Jimenez.
All right, 2020 CF 7776 AO. You're here on one count of drivewall license suspended as a habitual traffic offender, one count of possession of drug paraphernalia. Reviewed the affidavit, found probable cause, appoint the public defender. Set your bond at $1,000 on count 1, $100 on count 2. You also qualify for pretrial release. Do you want to post the bond to get out, or do you want to be released to the pretrial release program?
I would like
PTR, you don't have to post a bond, but you'll be monitored similar to probation.
Yes, I would like a pre-trial release, being
All right.
that.
Thank you.
Thank you.
Conditions, Your Honor?
Thank you, Your Honor.
Any
God bless you.
conditions? No.
Your name, sir?
Owens.
Johnson was the one that you wanted to push to the end?
Johnson and Eckert.
And what?
Eckert and
Yeah,
Johnson.
we did Eckford already, all right.
And I'm gonna need a minute on the next one.
Do we have Kirkland?
We're talking about waiving Kirkland?
I don't know, where are we at with Kirkland?
Oh, did you say he's medical? We're asking for a waiver and for a bond to be set.
Okay, Mr. Williams, he's medical? 2020 CF 7111AO. Will appoint the public defender, waive his appearance. According to this arrest warrant, his bond is set at no bond with conditions, no contact with the victim. IA judge may modify. Any input from the state with regards to release?
Asked to stay at no bond, Your Honor.
And the rationale behind the no bond?
We asked you to consider all the facts in the affidavit to find proof, evidence, or presumption grade and hold him at no bond.
Is it a PBL or capital?
Your Honor, I don't think it is a PBL. I believe it was just set no bond because it's one of those offenses that has to be set by an IA judge.
That's what I think as well. If the state tells me I'm wrong, I'll look it up. I mean, I'm on its face, I agree with the public defender, but let me just make sure we do it right. 794011. 4B. F1. All right, I'll set his bond at $15,000, no contact with the alleged victim. Thank you. And do we have Mabuda?
Medical, Your Honor.
Okay. 2020 CF 2559AO, 3 failure to appears. Has the public defender already been appointed on this? Do we know? I'll temporarily appoint if they haven't. The bond set at no bond on each.
And he also has an immigration hold.
Okay. Defendant failed to appear for arraignment on June 22nd. He also has a hold for immigration. All right, how about
Your Honor, we asked that the failure to appear be modified because it depends which judge, but some are giving the IA judges discretion due to the arraignments during this period.
There's nothing on here that says can be, may be, or to be modified. So I'll stay the bond at this point. All right, do we have Jeremy Owens?
Yes, sir.
That's you?
Yes, sir.
2020 CF 7788 AO, dealing in stolen property via arrest warrant. According to this warrant, your bond is set at $2,500. I'll appoint the public defender, and I'll stay your bond.
Your Honor, the ASA for the Eckford and Johnson cases are here when you're ready.
All right, we'll just do them at the end.
Morning,
ASA, huh?
Yes, sir.
Okay.
Good morning.
How are you?
Good, how are you?
Been a while. All right.
Yes, sir.
We pushed them to the end. We'll probably be there in 15 minutes or so.
Sure, thank you.
All right. All right, we're done with this gentleman. I stayed his bond. Your name, sir?
Jackie Ponder.
All right, so this looks like 2020 CF 7390 AO. Your bail bondsman came off his bond. Is that what happened?
I don't believe so.
I don't know.
No. Know what this
It is
says?
an endorsement, and the bond was set.
I'm sorry, Courtney, can you tell me his name again?
Ponder, that's what that is.
Jackie Harnell Ponder.
It's an endorsement.
All right, sir. So your bond on this case is failure to register. Your bond set at $2,500. Okay. All right. Looks like you had bailed out, but then they endorsed the bond.
What does that mean? I don't understand.
Did you think you bonded out?
What did you say, sir?
Did you think that you had bonded out on this charge?
I don't know. I just went to court yesterday, so I don't know what I'm coming back for. I don't understand.
He's also here on another page to register.
Yeah, I
right.
came yesterday.
Right, and that was on a different case. Same charge, different case.
Yeah, because the dude made a mistake and he's saying that I didn't have
Hold on. Just don't. Before you say anything, I just don't understand you have a right to remain silent. Anything you say can and will be used against you. So I just don't want you to admit anything or say anything to get you in trouble. So what's his bond on his other case? Are they both at $2,500?
The other one is $1,000, Your Honor.
Okay. All right. So your bond in yesterday's case is $1,000, and this one's set at $2,500.
Excuse me,
Thank
sir.
you. Yes.
But I already had a bond. Was out on bond already for the same thing. But this dude right here gave me his card, say he gonna help me with it because I'm not from here. I don't know nobody. I'm finna lose my job.
All right. You have a public defender on this case. Is there anything you want to tell your client?
Yes, Mr. Ponder, just go ahead and call the lawyer on that piece of paper. They put a bond on the case that you thought you had bonded out on before. So now you have two cases. So if you want to bond out, you can. If you can't, call your lawyer, okay?
Bond out on this case. I already had bonded out on one case.
You've got another bond on it. So go ahead and call your lawyer if you have more questions, okay?
So what I go about doing this?
Okay.
I'm not from here. I don't know nothing what's going on. I'm finna lose my jobs.
Call your lawyer. Thank you.
I don't have a lawyer.
Yes, you do.
I appointed a public defender to represent you, sir.
So I got to pay a double bond now?
You
When
have
I already
two
bonded
cases,
out
yes.
on the same thing? I'm bonding out again on the same thing I already paid a bond for?
Correct.
So
Thank you.
how you go about doing that?
I didn't do it, sir.
Thank you.
I don't understand, man. This kangaroo court.
And who do we have next?
Reynolds.
Is it Miss Reynolds?
Medical unit.
Okay. 2020 CF 7784 AO, burglary of an occupied dwelling, petty theft. Temporarily appoint waiver roll.
Waive.
All right, reviewed the affidavit, found probable cause, appoint public defender, I'll stay the bonds with condition no return to the scene. And Ms. Reynolds?
Robinson. Reynolds is medical, y'all.
Medical for Heather Reynolds?
Yes.
All right, 2020 CF 7785, so she had 2 cases, I'm sorry. On the second case, burglary of an occupied dwelling, burglary of a conveyance, and a petty theft. I'll stay the bonds on that case, same conditions. And you're Miss Robinson?
Yes, sir.
Okay, she had 2. 2020 CF 7754 AO, aggravated battery with a deadly weapon via arrest warrant. According to this warrant, your bond is set at no bond, with conditions to be set at initial appearance. Any input from the state?
2,500, Your Honor.
Ruby Robinson, I'm sorry, how much?
2,500.
Okay, any input from the defense?
Miss Robinson, that's your last name, correct?
Yes, ma'am.
How much money can you afford?
About 150, something like that.
Your Honor, may I ask the bond be set at 1,500?
All right, she's got prior convictions for armed burglary with a weapon. She's been at DOC 4 times. I'm inclined to stay her bond at the 2,500. No contact with the alleged victim. Do not possess any guns, knives, or weapons. Thank you. All right, ma'am, your name?
No, Rosario bonded, Your Honor.
Oh, okay. Rosario bonded?
Yes.
All right. And who's this gentleman?
Leroy Christopher Quentin Royal, the 4th.
All right, sir. 19 CF 419 AO. You're here on 4 failure to appears. According to this, you failed to
No,
appear.
sir, I only have 1 failure to appear.
Well, it's 1 case with 4 counts.
Okay.
Yeah, I'm sorry. It's possession of a firearm by a convicted felon, carrying a concealed weapon by a convicted felon, resisting officer without violence, and exposure of sexual organs. You failed to appear for trial management conference on June 11th.
Sir, may I say one thing? I bonded out on May the 3rd.
Hold on. I just don't want you to say anything and get in trouble. Don't worry, I'll give you an opportunity.
Okay.
Your bond on this is set at no bond. You have a lawyer. Your lawyer's going to talk to you real quick, and then you guys can do whatever you want to do here.
Mr. Royal, at this point, this judge can't modify what is in that warrant, but there's a phone number on there right now. There's a lot of miscommunications about court dates. Go ahead and call your lawyer, and we'll try to see if we can get you a bond motion, okay?
No, Honor, please, Your Honor. You're not my lawyer. Your Honor. Your Honor, may I say something?
Yeah, well, your lawyer,
My attorney is Jeffrey Stone.
you want me to roll this to tomorrow so you can contact Mr. Stone?
Your Honor, I bonded out May the 3rd. I had a court date June the 3rd. I went there June the 3rd. They said the courtroom was closed. I was waiting on, they said they were going to mail out a court date. They never mailed out the court date. And then by the time, if you read the affidavit, I went to the courthouse to find out my new court date, and that's when I was apprehended for the warrant. I went there to find out my new court date. They said the courtroom had been closed the whole June, and that's how I got the warrant. They just reopened up the courts.
Well, they opened up the courts on June 5th, sir, and
And my court date
believe
was
me,
court date was June 3rd. See,
listen, I understand there's a lot of confusion. Unfortunately, I don't believe the law allows me to do anything on this case at this point in time. What
Okay.
I can do for you is I can roll this case to tomorrow morning at 9 a.m. That'll give you the rest of the day to contact Mr. Stone, who is your lawyer, who can contact the judge that issued this warrant. Who was the judge? I didn't see who was on.
Judge Tanya Wilson.
And who is it?
Judge Tanya Davis Wilson.
Okay, and he can talk to Judge Wilson, and hopefully she can get you a bond, and then when you come back tomorrow morning, whatever judge is here, it's not likely will not be me, can say, sir, I have good news. Your lawyer talked to Judge Tanya Wilson, and she gave you a bond.
There's no way. Can I plea out now then?
No, sir. No. But if you want, I can either send you on your way now with your bond of no bond, or I can roll this to tomorrow, give you 24 hours, 22 hours to call your lawyer and hopefully get a resolution. So when you come back tomorrow, we have better news for you.
All right. I'd like to come back tomorrow then.
Okay, that's the best I can do. And in the meantime, I'll ask the state attorney to send an email to Judge Wilson and see if she'll respond to that.
Can you tell the judge I went to the scheduled June the 3rd court date? The whole courthouse was closed. They told me to leave.
I can't, but sir, that's your lawyer's job. But I've asked the state attorney, the prosecutor, to send an email as well. So hopefully we got the defense and the state working for you.
I'm sorry, Your Honor.
I said I've asked the prosecutor to send an email to the judge as well, so hopefully the state attorney and your defense attorney are working on this right now.
Yeah, I went there June 3rd. The courthouse was closed.
Okay. Thank you, sir. I'm doing what I can. I know it's not a good situation. All right. Your name, sir?
I kind of lost my voice, so it's Christian Rueda, RUEDA.
2020 CF 7790AO, aggravated assault with a weapon. Reviewed the affidavit. Found probable cause. Point the public defender.
100% innocent. How you say that in Spanish?
I don't know.
Okay. 100% innocent then.
Okay. Set your bond at $2,500. No contact with the alleged victim. Do not possess any guns, knives, or weapons. Good luck, sir.
Okay. So my release date?
Your name, sir?
Stevens.
All right. Thank you. 2020 CF 7263AO. You're on one count of fleeing or attempting to elude a law enforcement officer via arrest warrant. According to this warrant, your bond is set at no bond with conditions to be set by the initial appearance judge. Any input from the state, I'll appoint the public defender.
Defer the court, Your Honor.
What?
Any input from the defense?
No, Your Honor.
I'll set your bond at $2,500.
I'm sorry, Your Honor. I'm new to this. Can you repeat? I didn't hear it. Well, I was.
So you're here on fleeing and attempting to elude a law enforcement officer. It's an arrest warrant. The judge set your bond at no bond, which means you can't get out. I just set your bond at $2,500. At $2,500. So you have
Thank
a
you.
bond. I also appointed a lawyer to represent you.
Okay, thank you.
Thank you. Your name, sir?
Andrew Stewart.
All right, so you have two cases. The first one is 20 CF 7766AO, aggravated battery with a deadly weapon, battery of a uniformed light security officer, resisting officer without violence. You're also here in 2020-198804, violation of probation. On your violation of probation, your bond on that is set at no bond. It's out of Volusia County on 2 counts of obstructing a criminal investigation. On your new case, your bond on count 1 is set at $2,500 on count 1, $150 on count 2, and $100 on count 3. Do not possess any guns, knives, or weapons, and no contact with the alleged victim. And I pointed the public defender on that case is what I meant to say. Thank you. And your name?
Carolyn Woodson.
Your name?
Carolyn Woodson.
All right, what happened to Daniel Thibodeau? All right, 2020 CF 7805AO, temporarily appoint a waiver role, medical.
No, he bonded.
Wait.
Oh, he bonded? I thought you said
Bonded, Your Honor.
Yeah.
Oh, bonded. Okay, never mind. He was going to get PTR. All right, Carolyn Woodson.
Yes.
Okay. You're out on bond on an ag assault with a deadly weapon, 2020 CF 4483AO. You're here today in 2020 CF 7779AO, robbery, petty theft, resisting merchant, and battery. I reviewed that affidavit, found probable cause, point the public defender. State, if you want to tell me what the status is of the case that she's out on bond. On your new case, I'll set your bond at $1,000 on count 1 and $100 on each subsidiary account. No return, and do not possess any guns, knives, or weapons. Has the charge has been filed on for the 2020 CF open case?
I don't think so, Your Honor.
No? All right, I'll take no action on that case. Thank you. Your name, sir?
Darian Fleming.
What happened to Jesse Key?
He's medical, Your Honor.
He's medical.
Yes, Key.
Out on bond and an FTA with a MHPTR release. Appoint the public defender. Waive.
Yes, Your Honor, waive.
Okay. All right. 2020 MM 3549. I'll take no action on the cases. Out on bond and MHPTR on the FTA. All right. Your name, sir?
Darian Fleming.
All right, 19 CF 572 AO, violation of probation on one count of lewd and lascivious molestation with a victim between the ages of 12 and 15. According to this warrant, your bond is set at no bond. I'll appoint the public defender to represent you, sir.
Any conditions?
No, there were no conditions. Just stated no bond. Your name, ma'am?
Summerlin.
All right, I got another Brian Key. Medical. That's a VOP, temporarily appointed to PD 19 CF 17143, waiver roll.
Going in and out if you ask me that.
Brian Key, waiver roll.
Waive.
All right. VOP, the bond set at no bond. Sheila Summerlin, that's you, ma'am?
Yes, ma'am. Yes, sir.
That's all right. 19 CF 15054 AO, violation of probation. According to this warrant, your bond is set at no bond. I'll appoint the public defender to represent you.
Okay.
Thank you. Your name, sir?
Daniel Humphreys.
All right, your ROR on disorderly conduct 2020 MO 604 AO. You're here today on an out-of-county warrant. 19 CF 1157. Fraud $50,000 or more. Your bond on that is set at no bond. And so what do we do with this gentleman? Do we tell him we're going to reach out and then bring him back?
And appoint the public defender.
All right, I'll appoint the public defender. They're going to reach out to the judge that issued that warrant in that county and see if they can get you a bond. We'll bring you back when we hear back from that judge, okay?
Yes, sir.
No action on the out on bond. Thank you. Your name?
William Miranda.
You said William Miranda?
Miranda, yes, sir.
Okay. 2001-86 CTA out of county warrant on a no valid driver's license. According to this, it's out of Columbia County. The bond on this is set at no bond, signed by Judge Coleman from 20 years ago in 2 weeks. We're going to reach out to Judge Coleman if he's still there, or whatever judge is assigned to that division, and see if they're entitled to give you, if he's going to give you a bond. I'll appoint the public defender to help you do that. You understand?
Yes, sir.
All right, thank you. Your name, sir?
My name is Christopher Montgomery.
All right, 2019-00425. It's a violation of probation out of DeSoto County. According to this, fleeing and eluding, possession of a controlled substance, transporting forged bills. Your bond on that is set at no bond. We appoint the public defender to do the same thing on these? Yes? It's a on VVOP? Okay. I'll appoint the public to, we lost her. Hold on. Let's wait for her to come back. Okay, she's back. All right. She's gone again.
I'm sorry. You didn't lose me. I turned the video off because I'm finding a charger.
Okay. So
you can keep going.
You did hear the last two cases?
Heard it all. You've appointed.
Yes. All right. Thank you. All right. Your name?
Tarian Newton.
All right, 189877 MMA out of county warrant out of Seminole County. Possession of failure to appear for pretrial conference. Your bond is set at $2,000. That's it, right? Yeah, no valid. There's no or.
They didn't separate.
Oh, what's the other one?
They didn't separate. The total bond is 2,000.
Okay, that's right. Oh, yeah, I saw the 2 counts. I was looking to see. All right, yeah. So your total bond is $2,000 out of Seminole County, sir. Your name?
Dennis Summers.
2009-10603 out of County Warrant. Out of Volusia County. According to this, your purge is $970. You understand?
I just got accepted into a program with the VA yesterday. I'm homeless. They're going to help me with being homeless as well as getting a job so I can address my back child support, but unfortunately this is going to hinder it.
Okay. All right, so we'll reach out to Volusia County and see if they're willing to adjust that 970. And when we hear back with either good news, bad news, or no news, we'll let you know if you don't purge out. Okay?
Yes, sir.
All right. Thank you.
Yes, sir.
One more, and then we're cheers done. And your name?
James Eckford.
All right. What happened to Christopher Taylor? Medical. Out of county. Temporarily appoint the public defender. Waive or roll? It's a VOP out of
Waive. Did you hear me, Your Honor? Waive.
Okay. All right. Thank you. And that brings us to Eckford.
Yes, sir.
And can I get appearance from the state?
Yes. Good morning, Your Honor. Tom Wazorek on behalf of the state of Florida.
All right. Mr. Eckford, you were here on a few cases. It looks like you were here in 20 CF 7795 AO, which is fleeing or attempting to elude a law enforcement officer. 20 CF 7718 AO, first degree murder with a firearm. And 2020 CF 4678 AO, armed burglary of a conveyance with a firearm. Burglary of a conveyance, grand theft, third degree of a firearm, grand theft, third degree, greater than 10,000, less than 20,000, one count of criminal mischief, greater than or equal to $1,000. That one is via arrest warrant. According to that case, your bond on that is set at $5,000 on count 1, $1,000 on 2, $500 on 3, $1,000 on 4, $500 on 5, for a total of $8,000. I'll address all the bonds at one time at the end. And then he's got 20 CT 4001 AO, driving while license suspended. And the bond on that, I think, is set at $500. I'll appoint the public defender on all of your cases. And let's talk about the first degree murder with a firearm. State, any input with regards to release?
Yes, Your Honor. The state's requesting that the court continue to hold the defendant without bond. And additionally, I'm also requesting that the court impose as a condition of any pretrial release that the defendant have no contact with Jacoya Polk. And the last name is spelled P as in Paul, O-L-K, first name J-A''COYIA. Her name is contained within the affidavit for the arrest warrant. Okay. Oh, and also no contact with the co-defendant.
All right. Any input from the defense?
Your Honor, we leave this to the court's discretion.
I reviewed the affidavit in support of the arrest warrant. I do find proof evident presumption great. I reviewed his history. I'm inclined to stay the bond at no bond at this point in time, with no contact with the alleged victim, no return. Do not possess any guns, knives, or weapons, and no contact with the co-defendant. On the 20 CF 467.
I beg your pardon. The one individual isn't a victim, it's a witness. That was one I previously provided the name. I don't know if that was who Your Honor was referring to.
Who was the person that you listed?
Jacoya Polk.
And what was her role?
A witness.
Oh, okay, I'm sorry.
Yes, sir.
She's the witness on the murder case.
That's correct.
Okay. sorry, because he's got four or
Not
five
victim.
cases in front of me.
Yes, sir.
All right. On the armed burglary, I'll set count 1 at $7,500. Count 2 will be 150. Count 3 150. Count 4 150. Count 5 150. I'm sorry, 100 on count 5. No contact, no return, and do not possess any guns, knives, or weapons. On the 2 driving offenses, I'll set your bond at 100 on each. Oh, I'm sorry, on the Dwillis 100, and on the fleeing and eluding 1,500. Is that everything?
Your Honor, may I say something, Mr. Eckford?
Sure.
I'm just advising you to not say anything in general unless you're only speaking to your attorney, because jail does have videos. An attorney will come to speak to you and explain that more thoroughly, but I just wanted to make sure you knew, okay?
What did you say?
Yeah, you're
Just don't
cutting
just-
in and out.
I'm
Mr.
sorry.
Eckert, understand that you have a right to remain silent. Anything you say can and will be used against you. Your lawyer has advised you not to talk to anyone about this case, that there are video cameras in the jail, and to wait for your attorney to come and talk to only your attorney about this case.
Okay.
Okay, is that what you said, counsel?
That was exactly what I said. Thank you.
Okay, all right, thank you. All right, and then that leaves us Mr. Johnson. That's the last case. Your name, sir?
Delaney Johnson.
2020 CF 7719AO, one count of first-degree murder via arrest warrant. According to this warrant, your bond is set at no bond. I'll appoint the public defender to represent you. Any input from the state with regards to release?
Yes, Your Honor. Again, Tom Mazurek on behalf of the state of Florida. The state's requesting the defendant continue to be held without bond, and that as additional conditions of pretrial release, he be ordered to have no contact with Chiquoya Polk, and also no contact with his co-defendant, James Eckford.
All right, any input from the defense?
We leave it at the...
The affidavit is the same in this one, correct?
Yes, sir.
Okay. 'Cause I didn't have an affidavit for this one. I had an affidavit for the other one. I just assumed they were co-defendants, but
They are, Your Honor.
okay. I just wanted to make sure. All right, reviewed that affidavit previously on the other case. Find, prove, evidence, presumption, grade. I'll stay your bond. No contact with the co-defendant. No contact with the witness. Do not possess any guns, knives, or weapons. Do not return to the scene. Do you want me to give him the same advice you gave the last gentleman?
Yes, please, Your
Okay. All right, sir. Understand that you have a right to remain silent. Anything you say can and will be used against you. So don't talk to anyone about this. Don't talk to anyone about this case except for your lawyer. Understand that there are cameras in the jail and that they can see you. So wait to hear from your lawyer and don't talk to anyone else about it, okay?
Yes, sir.
All right, thank you. And I'm just relaying that information from your lawyer just so it's clear because her connection's been kind of spotty. I'm not advocating for anybody. Is that everything, everybody? All right, thank you.
Thank you, Your Honor.
Good to see you too.
Good to see you too.
Bye.
Even though it's just a bike of you, but it's good to see you.
I got to see you in person. Mr. Williams, I did it. Bye.
Microphone on?
We can't hardly understand you, Your Honor.
Okay. Is this better?
Yes, sir.
Okay. All right, I'm Judge Epperson. We're here for arraignments, and I want to take a moment and explain the purpose of the hearing. An arraignment has two main purposes. The first is for the court to tell you the criminal charges that might have been filed against you by the state of Florida. The second purpose is for you to tell the court today how you wish to plea, whether you wish to enter a plea of guilty, a plea of not guilty, or a plea of no contest. Before making that decision, you should understand the legal rights that you have in court. Under the law, you're presumed innocent. You have the right to a jury trial where the state of Florida would have the burden of proving your guilt beyond all reasonable doubt to a unanimous jury. You also have the right to a lawyer, and if you can't afford to hire your own attorney, I can and will appoint the public defender to represent you. You do have the right to remain silent today in court other than telling me how you wish to plea. Anything that you say could potentially be used against you in the future by the state attorney's office. We do have 2 assistant state attorneys here in the courtroom today, of course. All right, if today it's your decision to enter a plea of not guilty, I'm going to set your case for pretrial conference and give you a few weeks to prepare your case for trial or possibly work out a resolution with the state. If today you decide to enter a plea of guilty or a plea of no contest, I would accept that plea today, impose some type of sentence, and your case will be finished today except for carrying out whatever sentence is imposed. We're in county court. That means all the cases on our docket this morning are misdemeanor offenses. There's 2 types, first degree and second degree. The difference between the 2 offenses is the maximum punishment under the law. First degree misdemeanors are punishable by 1 year in jail and a $1,000 fine as a maximum. Second degree misdemeanors are punishable by a maximum sentence of 60 days in jail and a $500 fine as a maximum. So that's what an arraignment is all about. I'll tell you the charges. You tell me how you wish to plea. If you wish to enter a plea today, I'll accept pleas today. Just come to the podium when I call your name. Make sure you're speaking directly into the microphone so that you can be heard, and we'll get started. I believe we might have private counsel here on one matter, so I'll take that case first. Okay. All right, good morning.
Good morning, David Hill for Mr. Wilfredo Rivera Rodriguez. Can the court hear me through this?
Say it again?
Can you hear me through this?
I can, yes.
Judge, I've spoken to the state and we've agreed upon a proposed resolution.
Okay, just a moment. Sure. Okay, sir, please state your name.
I'm Wilfredo Junior Rivera Rodriguez.
And your date of birth?
August 1493.
Okay, Mr. Hill, the anticipated disposition?
Anticipated disposition, Your Honor, it was a total of 30 days in the Osceola County Jail. He has got 11 days on the violation of probation case contained in 2020 CT 354. And then on the other 2 cases, he does not have any time served yet. I believe the state's agreed to basically make it an additional 20 days on CT 1356 and CT 1357 so that he basically gets out after an additional 20 days because he's already done 11. Does that make sense?
So, so I heard 30 days on 354.
Yes.
20 on the other 2 cases. Are those concurrent, consecutive?
Concurrent, Your Honor.
Everything concurrent?
Yes, Your Honor.
Okay, all right, just one moment. All right, Mr. Rivera Rodriguez, if you agree with what your lawyer has said, please raise your right hand to be sworn.
Do you solemnly swear or affirm that the testimony you shall give to be the truth, whole truth, and nothing but the truth, so help you God?
Yes.
You can put your hand down. All right, have plea forms been completed?
No, Your Honor. I was just retained yesterday, so I have not been down to the jail to do that.
Okay. I'll go ahead and handle it without plea forms. Mr. Rivera Rodriguez, I'm going to deal first of all with the violation of probation case 20 CT 354. You were placed on probation for the offense of driving while license suspended with knowledge. You're accused of violating by committing a new offense of driving while license suspended, operating a motor vehicle with an expired license, as well as failing to pay your cost of supervision. Do you understand that if you admit violating the probation today, that you're giving up your right to have a hearing where the state would have to prove that you willfully violated?
Yeah.
You understand that?
Yeah.
Have you had a sufficient opportunity to consult with your lawyer about this decision?
Yeah.
Okay, since we're in court, if you could answer with a yes or a no, that way the court reporter can clearly know your responses, plus it's just a matter of decorum. Okay, so yes or no, but not yeah. All right.
Yes.
Okay, thank you.
I'm sorry.
That's okay. All right, are you today under the influence of any drugs, alcohol, or medication?
No, sir.
Do you understand that if you were not a United States citizen, a guilty plea in a criminal case could subject you to deportation from the United States?
Yes, sir.
Understanding these rights and consequences, do you wish to admit that you violated the probation in this case of driving while license suspended?
I'm Comster.
I couldn't hear you.
I'm Comster.
You saying no contest?
Yes, sir.
Okay.
Okay, let me back up. You're accused of violating your probation by driving while license suspended, operating a motor vehicle when your privileges were expired, and not paying your cost of supervision. I take plea of no contest in substantive cases, but not violations of probation, so.
I've seen both, Judge, but if the court wants to admit, that's fine.
So, Mr. Rivera, in the violation of probation case, I won't take a plea of no contest, but I will take a plea of guilty if that's what you wish to do. It's up to you, though. Do you wish to enter a plea of guilty to violating probation?
Yes, sir.
I accept your plea of guilty to violating probation. I will adjudicate you guilty, sentenced to 30 days in the Osceola County Jail with credit for the 11 days that you've already served. Back cost of supervision, just one moment. Let's see. Doesn't look like you owe any, okay? And the fines and costs have been paid. That's good. All right, so your probation is revoked and terminated. You have 30 days to appeal the judgment and sentence of the court. All right, turning to the two other cases, driving while license suspended with knowledge in 20-1357 and 20-CT-1356, expired license more than 6 months. Do you understand by pleading no contest to these offenses that you'd be giving up your right to have a jury trial?
Yes, sir.
You've already told me today that you're not under the influence of any drugs, alcohol, or medication. You understand that these pleas would subject you to deportation if you're not a United States citizen.
Yes, sir.
And you've had a chance to meaningfully consult with your attorney about these decisions?
Yes, sir.
State have a factual basis for each?
Your Honor, the defense and I have spoken before the plea and agreed to stipulate to a factual basis.
Yes, Your Honor, I would stipulate to a factual basis on these.
All right, Mr. Rivera Rodriguez, do you wish to enter a plea of no contest to driving while license suspended with knowledge?
Yes, sir.
I accept your plea of no contest to this offense. Adjudicate you guilty, sentenced to 20 days in the Osceola County Jail. There are mandatory court costs of $273. I'm ordering that you pay that to the clerk of court within 60 days of your release from custody. This sentence, pursuant to the plea agreement between the parties, will run concurrent with case 20-CT-354. You have 30 days to appeal the judgment and sentence of the court. And then lastly, turning to case 20-CT-1356, do you wish to enter a plea of no contest to operating a motor vehicle at a time when your privileges were expired for more than 6 months with an offense date of May 26, 2020?
Yes, sir.
I accept your plea of no contest, adjudicate you guilty, and sentence you to 20 days in the Osceola County Jail. There's mandatory court cost of $273. And I'm simply ordering that you pay that in full to the clerk of court within 90 days of your release from custody. This 20-day jail sentence, pursuant to the plea agreement, runs concurrent with cases 20-CT-1357 and 20-CT-354. You have 30 days to appeal the judgment and sentence of the court. Okay. Concerning, I know there's a civil citation to do with, concerning these cases that we've just dealt with, anything else from the state or defense?
No, Your Honor.
No, Your Honor.
All right, there is a speeding citation in 20 TR 20104. I'll take a look at that.
I think it was 5 over, Judge. I'm not positive on that.
52 and a 35, Orange Avenue, and with the additional circumstance of driving on a suspended license while on probation for driving with on a suspended license. Mr. Hill, did you want to be heard on that?
Judge, I just would ask the court to consider, if the court's not inclined to assume and dismiss, to withhold on it.
All right, Mr. Rivera, if you wish to resolve that speeding ticket with a plea of no contest, I'd withhold adjudication of guilt and impose the minimum fine. However, the minimum fine is $256. Or I could set it for a hearing. Now, if you went to hearing and you were found guilty, the maximum would be $500 plus costs.
Well, you said first, sir.
Do you wish to plead no contest to the speeding ticket?
Yeah, the minimum, please.
I accept your plea of no contest. I'll withhold adjudication of guilt. I'll impose the minimum fine, which is $256. There's $33 in court cost, and that comes to $289. Given your other costs, I'm going to give you 120 days to pay that. That's 4 months to pay that in full.
Okay, thank you, sir.
All right, you have 30 days to appeal. All these cases are now resolved. All right, good luck. Thank you.
May the office of the public defender be withdrawn from all the cases of the defendant?
Yes, the defendant will need to be fingerprinted on these offenses as well, and the public defender is withdrawn based on counsel's representation. All right.
Thank you very much, Your
All
Honor.
right, have a good day. Stay safe. Thank you.
I got a question, sir.
Yes, your attorney's still here. Go ahead.
So I have to do, you sir, I have to do for 20 days?
Yes, sir.
Or that count altogether, the 30 days?
All of the cases are concurrent, meaning that they're running at the same time, but you didn't have any credit on the 2 cases that you pled to today, not the VOP, but the other 2 cases. So you have 20 days to serve on those. But they're running at the same time. It's not 40, it's 20.
You'll get another additional 20 days, and then you're done for everything.
I have to do 20 days and I'll get out?
Yeah.
Essentially, yes.
Okay.
And I'll say that from the court's perspective, your attorney worked out a very favorable resolution on your behalf.
Okay.
Thank you.
Thank you, sir.
All right.
Thank you.
Okay, let's go to number 2 on the docket, Jessica Clark. Jessica Clark. Okay, let's set Ms. Clark for jail arraignment 2 weeks out, and State, if you could make a note to do a transport order.
Yes, Judge.
Thank you very much. I see that number 3 has been set for pretrial. That's Adrian Evans has been set for pretrial, so he can be removed from the courtroom. Eric Franklin.
Jake Black on behalf of Mr. Franklin in case 19 CT 2265.
All right, Mr. Franklin standing before the court. Mr. Black.
Yes, Your Honor. My client intends to admit the violation as alleged pursuant to an agreement with the state for credit time served for 104 days and revoke and terminate probation.
Shonda, what day was Clark set for?
Mr. Franklin, if you agree, please raise your right hand to be sworn.
Do you solemnly swear or affirm that the testimony you shall give to be the truth, whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right, you can put your hand down. Mr. Franklin, do you understand by admitting the violation of probation, you're giving up your right to have a hearing?
Yes, sir.
Are you under the influence today of any drugs, alcohol, or medication?
No, sir.
Have you had a sufficient chance to talk to your lawyer?
Yes, sir.
If not a United States citizen, do you understand the plea will subject you to deportation?
Yes, sir.
You were placed on probation for driving under the influence. Do you admit you willfully violated in the following ways: not paying your cost of supervision, not reporting, not paying your fines, not doing your community service hours, not enrolling in the DUI school, and not completing the victim awareness program?
Yes, sir, but I did not admit guilt to driving under the influence.
No, I didn't say that you did.
Okay.
You were found guilty by a jury.
Yes, sir.
Do you admit that you willfully violated your probation in all these respects?
Yes, sir.
All right, I accept your admission to the violation of probation. Sounds like you didn't do hardly anything. I will adjudicate you guilty and sentence to 104 days in the Osceola County Jail. There's cost of $3,072. That doesn't just disappear. I'm ordering that you report to the Clerk of Court's Collections Department within 5 days of your release from custody for the purpose of making a monthly payment plan for this obligation. If you fail to report within 5 days, it would violate your sentence and could subject you to further incarceration for contempt of court. Let me take a look at your cost of supervision. Actually, there's also a $100 cost for the services of the public defender, so it's $3,172. Just one moment. I'm sure you owe cost of supervision. Yes. So there's $200 cost of supervision that you have not paid. That is due to Osceola County Probation. I'm ordering that you pay that within 90 days of your release from custody. Your probation is revoked and terminated. You have 30 days to appeal the judgment and sentence of the court. All right, so based on the agreement, I believe the defendant will be released on this case today, subject to any other holds. All right, thank you, sir.
God bless you, Your Honor.
You too, thank you. John Hare.
Jake Black on behalf of Mr. Hare in case 20CT202.
Hello, Mr. Hare.
Yes, sir.
And what will your client be doing today?
Yes, Your Honor. My client would be withdrawing his plea of not guilty and entering a plea of no contest to the charge of driving with license suspended with pursuant to an agreement for an adjudication of guilt, 15 days in the Osceola County Jail and court costs.
Charged as a second-degree misdemeanor. Yeah. All right, the court will certainly see this as a COVID special. Mr. Hare, I think you deserve more time than that, but I'll go ahead and go along with the plea agreement. Please raise your right hand to be sworn.
Do you solemnly swear or affirm that the testimony you shall give to be the truth, whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can put your hand down. Mr. Hare, do you understand by entering a plea of no contest to driving while license suspended with knowledge that you're giving up your right to have a jury trial?
Yes, sir.
If you're not a United States citizen, do you understand this plea will subject you to deportation?
Yes, sir.
Are you today under the influence of any drugs, alcohol, or medication?
No, sir.
Do you understand that if you drive on a suspended license again, that this conviction could be used against you as well as your convictions in the past? For example, the one from February of 2017 and also a prior from 2011.
Yes, sir.
Has anyone made any threats or promises to persuade you to plea today?
No, sir.
Party stipulating to a factual basis?
Yes, Your Honor. Yes, Your Honor.
Thank you. I accept your plea of no contest, Mr. Hare. I will adjudicate you guilty. Sentence you to 15 days in the Osceola County Jail with credit for the 12 days that you've served. Court costs are $273, a $100 cost for the services of the public defender for a total of $373. You must report to the Clerk of Courts Collections Department within 5 days of your release from custody for the purpose of making a monthly payment plan for this obligation. Make sure you do that.
Yes, sir.
All right, you have 30 days to appeal the judgment and sentence of the court, and the defendant needs to be fingerprinted. Anything else from either side?
No, Your Honor. No, Your Honor.
All right, thank you, sir.
So I got 12 days credit?
Yeah, 15 with credit for 12.
Okay, thank you, sir.
Let's see. Francisco Hernandez. Okay. Okay, so we don't need to deal with Francisco Hernandez. That case has already been set for the next hearing. Cheyenne Malcolm is in the Orange County Jail, I see, as a note.
Yes, Your Honor. Mary Jane Cooper on behalf of Miss Malcolm in 19MM 3390. She is in Orange County Jail.
Okay. So we will set Cheyenne Malcolm for jail arraignment. I would say it's just an adjacent county, but we'll set it in an abundance of caution 2 weeks out for jail arraignment. And state if you could do a transport order.
Yes, Judge.
Thanks. July 9th for jail arraignment.
Thank you, Your Honor.
Thank you. Okay, moving on to Jose Morales Santiago Jr.
Mary Jane Cooper on behalf of Mr. Morales Santiago Jr. in 19MM 300. Your Honor, the defendant was provided with the level 1 drug diversion package in the jail. He read it, completed a certificate, and he has it with him on his person.
Okay. State.
Brad. So I'm sorry, you said that he was able to complete that?
Yes.
Okay. Based on defense's statement that they have at least been informed of completion of drug diversion level 1, state would announce the no pros for 19MM 300.
Okay, Mr. Morales Santiago, what are those papers that you have there with you?
The level 1 drug diversion program.
Okay, were you able to read it all?
Yes, sir.
What was the most important thing that you learned in reading that?
There's a lot of drugs out there. Pretty much stay away from them.
Okay, all right, that'd be a good idea.
Yeah, right.
That'd keep you out of orange, maybe, although I like orange. All right, your case has been dropped by the state of Florida. They've dismissed the charges because you took that educational course, all right? Yes, so you'll be released on this case today, subject to any other holds that you might have. Thank you. Do you understand that?
Yes, sir.
All right, good luck, thank you. Jordy Negron Lugo.
Mary Jane Cooper on behalf of Mr. Negron Lugo in 20MM 683 and 20MM 1367.
Hello, Mr. Lugo, your date of birth?
March 26, 98.
All right, Ms. Cooper.
Yes, Your Honor. Today, the state attorney, Morris, who has this case, provided an alternate offer, which I was attempting to get back in touch with the client. It is more favorable, so I know he will accept it. But it is, just to put on the record, it's an adjudication of guilt. It's concurrent for both of these. Adjudication of guilt, credit for the 21 and 20 days time served, but 30 days in jail. Sorry, 30 days in jail with 21 and 20.
Time out, I'm sorry. Okay, so let's start with 683. What was the offer in 683?
30 days concurrent with 1367.
Okay, and the offer in 1367 in terms of the time?
30 days in concurrent with 683.
Okay, who is Morris?
That is the state attorney whose case this is.
Oh, okay.
Mr. Bradley Morris.
Okay. And state, do you have, I know that the theft was charged as a theft with a prior theft conviction. Do you have history today? I was curious as to how many prior thefts the defendant might have.
There was one prior theft, Your Honor, and that prior theft was a withhold. Yeah, and that's just the one.
Appreciate it. Thank you. All right, so Mr. Negron, did you understand the offer?
Yes, sir.
Did you wish to accept the offers and enter pleas of no contest in each of these cases?
Yes,
Your Honor, there is a stipulation. The state required that he does not plead no contest, that instead he pleads guilty.
Okay, so did you wish to plead guilty in each of these two cases?
Yes, sir.
Please raise your right hand to be sworn.
Do you solemnly swear or affirm that the testimony you shall give to be the truth, whole truth, and nothing but the truth, so help you God?
I do, ma'am.
All right, thank you. You can put your hand down. Okay, Mr. Negron, do you understand that in each of these cases, that is the trespass and the theft allegation, that by entering a plea of guilty, you'd be giving up your right to have a jury trial?
Yes, sir.
Do you understand that if you're not a United States citizen, these pleas would subject you to deportation?
Yes, sir.
Are you today under the influence of any drugs, alcohol, or medication?
No, sir.
Has anyone made any promises or threats to persuade you to plea?
No, sir.
Do you understand that if you steal again, these theft convictions could be used against you to make your punishment worse?
I totally do, sir.
Have you had a good and sufficient opportunity to talk to your lawyer about these important decisions?
Yes, sir.
Turning first to the trespass case, do you admit or do you wish to enter a plea of guilty to trespassing on March the 10th of 2020 in the vicinity of 2200 Villa Verano Way in Kissimmee?
Yes, sir.
I accept your plea of guilty, adjudicate you guilty, sentence you to 30 days in the Osceola County Jail with credit for the 21 days that you've already served. Court costs are $273, $50 cost for the services of the public defender for a total of $323. You must report to the clerk of court's collections department on the second floor of the courthouse within 5 days of release for the purpose of making a monthly payment plan.
Sir, question. Will
Yes.
the court be closed by that time?
No, it'll most likely be open. You'll have to get a pass downstairs. You'll have to wear a mask, and then you can come on in and take care of your obligation.
Okay.
All right. Also, you're not to return to the location of 2200 Villa Verona Way. You have 30 days to appeal.
Yes, sir.
Turning next to the theft case, do you wish to enter a plea of guilty to theft with a prior theft conviction? It's alleged this theft occurred at Walmart in Osceola County on June 6th, 2020.
Yes, sir.
I accept your plea of guilty, adjudicate you guilty. Were the parties stipulating to factual bases?
Yes, Your Honor.
Yes, Your Honor.
Okay. All right, so I'm adjudicating you guilty of the theft with a prior theft conviction, sentencing you to 30 days in the Osceola County Jail with credit for the 20 days that you've already served. Pursuant to the plea agreement between the parties, this sentence runs concurrent with the jail sentence pronounced in 2020 MM 683. Also, you're not to return to the Walmart where this offense occurred at 4400 13th Street in St. Cloud. Don't go back to that Walmart. All right, this does conclude your sentences. Anything else? Court costs. There's court cost of $273, $50 cost for the services of the public defender for a total of $323. Again, you must report to the clerk of court's collections department within 5 days of your release from custody to make a monthly payment plan. 30 days to appeal. From the state and defense, anything else on this case?
Your Honor.
No, Your Honor.
All right, did you understand all of that, Mr. Negron?
Yes, sir.
All right, thank you. Good luck.
Have a good day. Good morning.
Two. Okay, turning next to number 16 on the docket, Stephen Lawrence Stone.
Ray Reed on behalf of Stephen Stone in 20 MM 1439.
All right, Ms. Reed, Mr. Stone, I think standing before the court. Mr. Stone, your date of birth?
1997, October 2nd, 1997.
Okay, and Ms. Reed?
The client would like to enter a plea of no contest for the following disposition: adjudication of guilt, credit time served, no return, and court costs.
Mr. Stone, is this what you wish to do?
Yes, sir.
I'll swear him in. Please raise your right hand to be sworn. Do you solemnly swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can put your hand down. Now, Mr. Stone, do you understand by entering this plea of no contest that you're giving up your right to have a jury trial?
Yes, sir.
If you were not a United States citizen, do you understand this plea will subject you to deportation?
Yes, sir.
Are you under the influence today of any drugs, alcohol, or medication?
No, sir.
Anyone threatened you to coerce a plea?
No, sir.
Do you wish to enter a plea of no contest to the charge of trespassing in a structure over on 5 Oaks Drive?
Yes, sir.
Party stipulating to a factual basis?
Yes, Your Honor.
Yes, Your Honor.
I accept your plea of no contest, adjudicate you guilty, sentenced to 42 days, Osceola County Jail, with credit for the 42 days you've already served.
Thank you, sir.
Court costs are $273.
Yes, sir. I'll pay them right away.
One moment. All right, there's a $50 cost for the services of the public defender, so the grand total is $323.
Yes, sir. Thank you.
I'll give you 30 days from the date of your release to make full payment. So that's 30 days to pay to the Osceola County Clerk of Court. Also, you're not to return to 7135 Oaks Drive.
To that place again.
All right, Mr. Stone, you'll be released on this case today, subject to any other holds that you have. Did you understand your sentence?
Yes, sir. I understand everything.
All right, good luck to you, sir. Thank you.
Thank you, sir.
Mm-hmm. Okay, let's move along to number 18, Vicki Wilson. Vicki Wilson.
Ray Reed on behalf of Vicki Wilson in 20 MM 1217.
Okay, Ms. Wilson, I think is,
She's in that next group, Your Honor, once we get these out.
oh, she's in the next group? Okay, okay, well, we'll take her up when she's there. Let me go back now. We do have a few interpreter cases. Now, let's see, how's that gonna work? I guess we'll have an interpreter arrive in the courtroom? Let's see. I'll call and find out. I don't either.
Good morning, Your Honor. This is Laura Bretaña, Spanish interpreter. The interpreter has not been sworn.
Okay, before we swear you in, this is Judge Epperson, and we're here doing jail arraignments by way of
Okay.
video at the jail. So I'm trying to figure out how we're going to do this.
Okay, let me.
Couldn't hear you. Just I don't understand. I mean, she's gone, but I don't know what. I'm going to call back.
Good morning, Your Honor. This is Theodore Leal, Spanish interpreter. The interpreter has already been sworn, Your Honor.
All right, Mr. Leal, I just had some inquiry. I wanted to let you know our circumstance here. So we're doing jail arraignments by way of video, of course, with the inmates at the jail, and we had about 4 cases involving the need for an interpreter. So I was wondering how we're going to be able to manage that.
Your Honor, the way it's being done is that the interpreter will speak through the speakers the way it's happening right now, and they should be able to hear fine from the jail.
Okay, we'll give that a test then. Just one moment. The first case we're going to call up is Christopher Abad, 2020 MM 1290. He is approaching the microphone, and he's now at the microphone. So we'll begin the interpretation if we can. You're already sworn?
Yes, Your Honor, the interpreter has been sworn.
Okay. Good morning, Mr. Abad. Can you please state your name and date of birth?
Buenos días, señor Abad. Por favor, da su nombre y su fecha de nacimiento.
Christopher Abad, 4/27/1993. I don't need an interpreter for the case either.
You don't? Okay. Have a seat. We're going to take up our interpreter cases while Mr. Leal is here. So if you can have a seat.
Okay, sir.
The next case we have, it says 11, but we've done that one. Okay. Arcadio Rosado Melendez, 2020 MM 273. He's standing at the podium. Mr. Rosado Melendez, your date of birth?
Señor Rosado Meléndez, su fecha de nacimiento?
Noviembre 25 del 80.
September 25th of 1980.
Noviembre.
Oh, November, sorry.
Sir, you've been accused of trespassing.
Señor, se le acusa de un acceso ilícito.
Offense date January 29th, 2020.
Hecho ocurrido el 29 de enero de 2020.
The location, the Big Easy Market.
El lugar es el mercado conocido como Big Easy.
Ms. Jimenez from the Public Defender's Office will address the court.
Yes, Your Honor.
Jiménez tratará con el tribunal.
Evelyn Jimenez on behalf of Arcadio Rosado Melendez on 20MM 273.
Jiménez representa al señor Ronald Meléndez en el caso MM 2739.
At this time, Your Honor, my client wishes to enter into a no contest plea.
En este momento el cliente quiere presentar una declaración de no me opongo a los cargos.
For an adjudication of guilt, 30 days in Osceola County Jail and court costs with a no return.
Y será una declaración de culpable, 30 días en la cárcel, pago de cotas judiciales y no volver al lugar de los hechos.
Mr. Rosado, if this is what you wish to do, please raise your right hand to be sworn.
Señor Rosado, si esto es lo que usted desea hacer, levante su mano derecha para que sea juramentado.
Do you solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Jura solemnemente que el testimonio que dará es la verdad, toda la verdad y nada más que la verdad. ¿Lo jura ante Dios? I do.
You can put your hand down.
Bajar la mano.
Mr. Rosado, do you understand by pleading no contest, you're giving up your right to a jury trial?
Señor Rosa, ¿usted entiende que cuando usted se declara no me opongo a los cargos, está renunciando al derecho que tiene de ir a un juicio ante un jurado? ¿Entiende?
Sí.
Yes.
If you're not a United States citizen, this plea will subject you to deportation. Do you understand this?
¿Entiende usted que si usted no fuera ciudadano de los Estados Unidos, esta declaración lo expone a una deportación? ¿Entiende?
Entiendo.
I understand.
Has anyone made any promises or threats to coerce you to plea today?
¿Alguien le ha hecho promesas o amenazas para obligarlo a que usted dé esta declaración del día de hoy?
No, señor.
No, sir.
Do you wish to enter a plea of no contest to trespassing as alleged?
Entonces, ¿quiere dar una declaración de no me opongo al cargo de acceso ilícito, tal como se le acusa?
Sí, señor.
Yes, sir.
Parties stipulating?
Yes, Your
¿De
Honor.
acuerdo?
Yes, Your
Sí,
Honor.
su señoría. Sí, señor.
Both parties stipulated. I accept your plea of no contest.
Acepto su declaración de no me opongo,
That was stipulating to a factual basis.
de acuerdo con los fundamentos del caso.
I adjudicate you guilty of trespassing and sentence you to 30 days in the Osceola County Jail with credit for the 17 days you've already served.
Así que lo declaro culpable del acceso ilícito, le impongo 30 días en la cárcel del condado, dándole el crédito carcelario por 17 días ya cumplidos.
Court costs $273, $50 cost for the public defender's office, total $323.
Así que son 273 de costas judiciales más los $50 para la Defensoría Pública, el total sería $323.
You must pay $323 to the Osceola County Clerk of Court within 90 days of your release from custody.
Y cuando sea liberado de la cárcel, tiene un plazo de 90 días después de su liberación para hacer los pagos ante la Secretaría del Tribunal.
You must not return to the Big Easy Market at 2201 West Columbia Avenue in Kissimmee.
Y no puede volver al mercado Big Easy, que está el 2201 de West Columbia en Kissimmee.
You have 30 days to appeal.
Tiene 30 días para apelar la sentencia.
Anything else from either side?
No, Your Honor.
Algunas de las partes no, su señoría.
Did you understand all this, Mr. Rosado?
¿Entendió todo lo que le dijimos, señor Rosado?
Sí.
Yes.
Thank you. Turning to the next matter involving our interpreter, Ariel Velasquez, 2009, CT 4379. Mr. Velasquez, please state your date of birth.
Señor Velázquez, su fecha de nacimiento, por favor.
18 de octubre de 1970.
October 18 of 1970.
In what year were you born?
¿En qué año nació usted?
En 1970.
1970.
Okay, because the docket says 1971. Just a moment. Citation.
Que escribieron 1971 aquí en esta lista. Un momento.
Just a moment. Yeah. What is his driving record? I'm going to place you under oath. Please raise your right hand to be sworn.
Levante mano derecha para que preste juramento.
Do you solemnly swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Jura solemnemente que el testimonio que dará será la verdad, toda la verdad y nada más que la verdad. ¿Lo jura ante Dios?
Sí, señor.
Yes, sir.
You can put your hand down.
Puede bajar la mano.
I need to ask you your date of birth one more time. It's very important that you're accurate in your answer because you're under oath now in court. All right?
Le voy a preguntar de nuevo la fecha. Es muy importante, la fecha de nacimiento, y recuerde que usted está bajo juramento aquí en el tribunal.
Sí, señor.
Yes, sir.
Our records reflect that you were born in 1971.
Según nuestro registro, la indicación es que usted nació fue en 1971.
No, 70.
No, 70.
Okay. Who's representing Mr. Velasquez?
Your Honor. I'm checking our files too.
Okay.
Un momento, estamos revisando los expedientes, su señoría.
We have October 18, 1970, Your Honor.
Aquí aparece 1970.
Yes, Your Honor.
And what is the source of that database?
This is when the case is open. I thought that information came directly from Benchmark and from the PTR officers. Those are the papers that we collect on arraignment, initial appearances, I'm sorry.
Todo de una base de datos, su señoría, de Park y libertad provisional. Ese es el dato que tenemos, de ahí viene.
I guess I'm asking, what is it that your eyes are laid upon now that tells you his date of birth is 1970?
Your Honor, it's on the charging affidavit.
En el escrito acusatorio, ahí donde estoy mirando.
I'm looking at the charging affidavit and it says 71.
Yo veo, dice 1971.
Un moment, Your Honor.
Un momento, su señoría.
Oh, okay. Let's take a look at that one. That says 71 even with greater clarity.
Your Honor, I am looking at the document in Benchmark, mark number 27 on the sequence.
Tengo el documento de...
Yeah. Okay. The defendant has affirmed under oath his date of birth is 1970. There is one report upon his arrest for the violation of probation that reflects 1970. Did the state wish to amend the information in this case to reflect a date of birth of 1970?
Yes. ¿La fiscalía quiere corregir eso, 1970? Sí, su señoría.
Mr. Velasquez, have you ever lived at 2212 Fountain Blue in Kissimmee?
Si en algún momento usted vivió en 22 Fountain Blue en Kissimmee, ¿usted vivió ahí en algún momento?
¿Cómo?
How is it?
Have you ever lived at 2212 Fountain Blue in Kissimmee, Florida?
Si alguna vez ha vivido en el domicilio o ha residido en el 2212 Fountain Blue, Kissimmee, Florida.
No, no, no.
No.
Can you run a DL with a different? Because, okay, so moving forward, his date of birth is 1970, and the record shall reflect that. Ms. Jimenez.
Yes, Your Honor. The offer conveyed by the state is admission of the violation, revoke and terminate probation, credit time served for 72 days, and court cost.
Si la oferta de la fiscalía es que él reconozca que violó su régimen de prueba, dar por terminado ese régimen de prueba y se le den los créditos por los 72 días y pago de costas judiciales.
The client wishes to accept that offer, Your Honor.
Y el cliente quiere aceptar esa oferta de la fiscalía, su señoría.
Mr. Velasquez, please raise your right hand to be sworn.
Levanta su mano derecha, señor Velázquez, para prestar juramento.
Actually, you've already been placed under oath, so you can put your hand down.
Puede bajar la mano, usted ya prestó juramento.
Mr. Velasquez, you were placed on probation for driving under the influence, and it's alleged that you willfully violated your probation by not completing the DUI school, not completing the victim awareness program, not completing the vehicle immobilization, not reporting to probation, and not paying your fines and costs of supervision.
Señor, presuntamente usted tiene una violación intencional a su régimen de prueba. Es intencional y sustancial, porque usted no cumplió con los requisitos que se le dio, por ejemplo, el requisito de ir a la escuela de alcoholemia, el requisito de tomar la clase de concientización de víctimas, el requisito de inmovilización del vehículo, no reportarse a los oficiales de prueba y no pagar las deudas que tenía pendientes.
Do you understand that by admitting the violation of probation today, you would be giving up your right to have a hearing where the state would have to prove it?
Ahora, ¿entiende usted que usted al admitir que usted sí violó su régimen de prueba, usted estaría renunciando al derecho que tiene de una audiencia donde la fiscalía estaría obligada a comprobar que usted violó el régimen de prueba? ¿Entiende?
Sí, señor.
Yes, sir.
Do you understand if you're not a United States citizen, this plea would subject you to deportation?
¿Entiende usted que si usted no fuera ciudadano estadounidense, esta declaración lo expone a una deportación? ¿Entiende?
Sí, señor.
Yes, sir.
Are you under the influence today of any drugs, alcohol, or medication?
¿Hoy está usted bajo efectos de drogas, de medicamentos, narcóticos, alcohol en algún momento?
No, señor.
No, sir.
Has anyone put any pressure on you to enter this plea today?
¿Alguien lo presionó a usted para que usted entregara esta declaración hoy?
No, señor.
No, sir.
Do you wish to admit the violation of probation in this DUI case?
Entonces, ¿usted desea de admitir que incurrió una violación a su régimen de prueba, en este caso de alcoholemia?
Sí, señor.
Yes, sir.
I accept your admission to the violation of probation, adjudicate you guilty, sentence you to 72 days in the Osceola County Jail with credit for the 72 days you've already served.
Entonces voy a aceptar este acuerdo de violación del régimen de prueba, declarándolo culpable, imponiendo 72 días de cárcel, pero dándole crédito carcelario por los 72 días ya cumplidos.
Sí, señor.
There's outstanding costs of $1,446 and a $100 cost for the services of the public defender for a total of $1,546.
Así que son $1,446 de cargo pendiente, más los $100 para la Defensoría Pública, con un total de $1,546.
I'm ordering that you report to the Clerk of Court's Collections Department within 5 days of your release from custody to make a monthly payment plan for this obligation.
Así que le estoy ordenando que se presente al Departamento de Colecciones de la Secretaría del Tribunal en un plazo que tiene de 5 días después de su liberación para que establezca el sistema de pago mensual.
That office is on the second floor of the Osceola County Courthouse here in Kissimmee.
Esa oficina queda en el segundo piso de los juzgados de Kissimmee. Okay.
There's $310 owed to Osceola County Probation for cost of supervision. This must be paid within 120 days of your release from custody.
También te queda debiendo $120 al Departamento de Régimen de Prueba. Tiene usted el plazo, perdón, son $310 y tiene un plazo de 120 días después de su liberación para pagárselo al Departamento de Régimen de Prueba.
¿Segundo día?
You mean the second day?
110 pesos al segundo día, ¿o cómo dijo? Disculpe.
I'm sorry. What did you say?
Okay, so there's $310 that you owe to Osceola County Probation for costs of supervision. I'm ordering that you pay that within 120 days of your release from custody. You have 4 months to make that payment to Osceola County Probation.
Sí, al Departamento de los Delegados de Pruebas del Condado de Osceola le está debiendo $310. Ahora, le ordeno que usted pague esa cantidad y tiene un plazo de 120 días después de que salga de la cárcel, o sea, 4 meses para pagar.
All right.
Okay, perfect.
Okay, sir, so your probation is revoked and terminated. You'll be released on this case today, subject to any other holds.
Así que se queda revocada ya lo que es el régimen de prueba. Usted saldría hoy si no hay alguna otra cosa pendiente.
Sí, señor. Thank you.
Yes, sir. That's fine.
Thank you.
Gracias.
Okay. Yeah. 1970, yeah. Okay, I believe that concludes our needs for Mr. Leal, our interpreter. Thank you, Mr. Leal. You're excused.
You're very welcome, Your Honor. Have a good day.
Thank you. Let me go back to Christopher Ebad, 2020 MM1290, number 1 on our docket.
Morning, Your Honor.
Good morning, Mr. Abad. You've been accused of, I'll take a look at the information, just a moment. You've been accused in a 4-count information. Count 1, resisting a law enforcement officer without violence. Count 2, threat to law enforcement officer. Count 3, criminal mischief with damage more than $200. Those 3 counts are first-degree misdemeanors. And then finally, trespass in a structure, which is a second-degree misdemeanor. Ms. Jimenez.
Yes, Your Honor. Evelyn Jimenez on behalf of Christopher Andres Abad on 20 MM 1290. At this time, the client wishes to enter a not guilty plea.
Not guilty plea is entered. These matters are set for pretrial conference on the following date and time. Yep.
It'll be set in August, but the date will be 4/20.
Date in August to be determined and provided. You'll be getting the notice of that shortly, the date. It'll be in August. All right, thank you.
Thank you so much.
Vicki Wilson. I think she was the one that was on the next.
She's the next group, Your Honor.
Okay, so we'll be in a brief. I think we've covered everyone for the 805 block. Is there anyone else that needs to be heard there that hasn't been?
Yes, sir, I have 4 other people.
Oh, okay, well, I'll just let those folks come forward and they can identify themselves on the record. I'm clueless as to who they are.
Good morning.
Your name, sir?
Ronald Garrity.
Okay, just a moment, Mr. Garrity. He is for 10 a.m., but we can move forward, I presume. Okay, so this is number 28 and number 29 on the docket. Ronald Garrity, 19mm 3734 and 19mm 3756. Now, this is a case in which I received notification yesterday. I assume that you are Ms. Castro? Yes, good morning, Your Honor. Good morning. Permission was requested that the victim could be heard telephonically, and I'm fine with that. Yes. Do you know the protocols of how we're going to make that happen? Do you have her number?
Yeah, I have her number. I wasn't sure if you wanted her to call us or for us to call her, so I had asked her to call us at 10.
Okay, but
I can provide her phone number so that she can be called so we can address it earlier.
if you could provide that discreetly to our clerks and we could move forward, but I need to know what's going to happen here. Is this going to be a plea?
Your Honor, I wanted to address the court off record, if possible.
No.
So the defense will be asking for a third-time evaluation. I was trying to speak with my client, and he was making incoherent statements. I don't know how he is today. And my concerns, and I know that I have raised them for the court before, and the court has denied it based on Dr. Tate's evaluation. I'm just making the same argument again, Your Honor.
Okay, all right. There were evaluations completed in the case, and Dr. Tate did determine the defendant to be competent. The court has made a finding of competency based merely upon the recital that's been put on the record. I'm not going to order another evaluation. So I just need to know whether or not this is going to be a plea or whether we set them for trial. Excuse me one moment.
Your Honor, may I approach the clerk? Oh, okay, thank you.
May I have a moment, Your Honor?
Yes. We can come back to Mr. Garrity if
Yes,
needed.
please.
He's not set till 10. And Mr. Garrity, if you'll have a seat, I'm going to come back to your case, but if corrections could assist with bringing up the next individual that hasn't yet been heard. Looks like some of these folks are set for 10 o'clock, but I can deal with them. All right, good morning, sir. Your name?
Charlie Bergante.
Last name again?
Bergante, B-R-I.
Okay. Okay, this is 2020 CT 476. Mr. Brigante, however, is represented by private counsel, Mr. McLean, and he's not yet here. So if you could have a seat. Let me ask, is Lorenisca Belzer there? He's standing in the back, I believe.
I'm sorry, sir?
Lorenisca Belzer.
Yes, sir. One moment.
Your Honor, I motion to continue in this case.
Yeah, just microphone there.
Your Honor, Jake Black on behalf of Mr. Belser in case 19MM3186. I filed a motion to continue because he has a felony case that is going into the mental health court program, and this case will go with it. It's a post-plea program. I provided documentation, and the state indicated they have no objection to a continuance.
State.
Carly Janicki on behalf of the state. Yes, no objection, Your Honor.
Mr. Belzer, good morning.
Good morning.
Your attorney, who's working on your behalf, is asking the court to continue this case. Are you okay with that?
Yes, sir.
I'll grant the requested continuance with the waiver of speedy.
Yes, Your Honor.
All right, so this case will be continued. We'll put it on the next pretrial docket, although if it goes to a diversionary court, that's fine. August.
August the 14th at 10:30.
August 14th at 10:30 is pretrial conference. Mr. Belser, you can consult further with your lawyer, but I'm going to go ahead and continue this case.
question.
Okay?
Am I being released or not today?
You're not being released today, but you're going to need to reach out to your lawyer about those issues.
Yes, sir.
All right. Thank you. Good luck.
Thank you. Bless you.
Let's see. Is Wesley Churchill by chance there?
That's the next group, Your Honor.
Okay.
The ones that we have in here are actually quarantine inmates.
Oh.
That's why we're trying to get them done, and then we'll get the next group out.
Okay, let's bring up the next person then. I'll let you bring up the folks.
This will be the last one. I thought the other two would be set.
All right. Sir, your name?
Justin James Campanan.
Justin is the first name. Yeah, it's number 38. Capana?
Yes, sir.
And this also is private counsel. These folks are scheduled for 10 a.m. and their attorneys are not yet here yet because it's 9:45. Unfortunately, I can't handle them. So I guess we're going to need to be in a recess until 10 a.m.
Okay.
All right, we're in recess till 10 a.m. I'm going to go off record until 10 a.m. Thank you.
Good morning.
All right, good morning, Mr. Garrity. We're here for, you can just put the mic near her. We're here for a pretrial conference on two matters, 2019 MM 3734, 2019 MM 3756, State of Florida versus Ronald Garrity. Just one moment while we make sure that the alleged victim can hear. She hung up? Is she? Okay. We're going to try calling again, I guess. Let's have personnel put their names on the record from the Public Defender's Office.
Emily Jimenez from the Public Defender.
From the state.
Sarah Castro on behalf of the state.
Your Honor.
Wait a minute, just a moment, because we're going to.
She isn't very technologically savvy, so it may be a little bit difficult to get on the phone.
She's probably trying to call, yeah. We're just awaiting the alleged victim to be able to contact the court.
Courtroom. Okay, Judy, give me 1 second. I'm going to put you on speaker, okay? Hold on.
Let's just do a test. We have an individual on the phone, and I need to make sure, this is Judge Epperson, I need to make sure that this witness on the phone can be heard and can hear what's taking place. Ma'am, are you there?
Yes,
Okay, and your name?
Judy Paccareri.
Your last name again?
Paccareri.
Okay, we're here in court for two matters for Mr. Ronald Garrity. We're here for a pretrial conference, and Ms. Jimenez is the attorney for Mr. Garrity. Ms. Jimenez, how is it that your client wishes to move forward today?
Your Honor, Evelyn Jimenez on behalf of Mr. Ronald Leo Garrity. This time my client wishes to plead to the bench.
Okay, here's the way this will work. I will take the pleas. After the pleas have been entered, I will hear from both the state and the defense before imposing sentence. All right, and at that time, after the plea, our witness on the phone would have an opportunity to be heard if she wished. Mr. Garrity, please raise your right hand to be sworn. Do you solemnly swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You can put your hand down and just step up to the microphone there. Mr. Garrity, in 2019, MM 3734, you've been accused of violation of a domestic violence injunction by communicating or contacting with an offense date of October 15th of 2019. And in case number 2019 MM3756, you've been accused in a 2-count information. Count 1, violation of a domestic violence injunction by communicating or contacting. And count 2, violation of a pretrial release condition on a domestic violence case. Offense dates October 21st, 2019 for count 1, and October 21st, 2019 for count 2. So these are the 2 cases. Your attorney has indicated that you wish to enter pleas of guilty in each case. Is that correct?
It's a plea of no contest.
Oh, I'm sorry. Pleas of no contest. Is that correct?
That is correct.
Do you understand that by entering these pleas of no contest, that you'd be giving up your right to have a jury trial in each case?
Yes.
Do you understand that if you're not a United States citizen, these pleas would subject you to deportation?
Yes.
Have you had a good and sufficient opportunity to talk to your lawyer about these important decisions?
Yes.
Are you under the influence today of any drugs, alcohol, or medication?
No.
Has anyone made any promises or threats in order to get you to plea today?
No.
Do you understand that the 3 counts that you're entering a plea to today are punishable by a maximum sentence of 365 days in the Osceola County Jail and a $1,000 fine?
Yes.
2 counts, Your Honor, right?
Well, there's 2 counts in one information and 1 count in the other, so that's a total of 3. That's what I was referencing.
And I misspoke to my client, Your Honor, and I will.
Unless there was no null processing,
No,
was
Your
there?
Honor, it was my mistake. I understood there were only 2 counts.
There's 2 counts in case number 2019 MM3756, the counts which I articulated on the record, and then there's a singular count in case 19 MM3734.
It was my mistake, Your Honor. I will need time to talk to my client again, if I may have 1 moment.
Okay, well, yeah, you can do that now. I mean, it's not going to, we can't really facilitate a private communication, but it's simply communicating the charges. So he indicated he understood that, but I'll let you go ahead and talk to him.
Mr. Garrity,
Yes.
you may be subject to 3 years of jail, not the communication that we have yesterday of 2 years.
Yes.
So do you want to plead to the bench or take and be subject to 3 years, or take the state offer for 2 years?
The 2 years.
Your Honor, it was just that the communication that I had with my client was for 2 years. And even though he just wanted to explain to a court, that's why we were pleading to the bench.
Okay, so what do you want to do then?
Accept the state offer of 2 years, Your Honor, if possible.
Okay, so tell me in particular what the offer was.
It was an adjudication of guilt, 360 a year for 19 MM 3734, it was a year, and consecutive to that year, it will be for 19 MM 3756, it was an additional year. I don't know how this, it was my mistake, I don't know if the state is seeing it differently on the counts. I cannot provide a statement on how are we splitting the year on the second case. May I have a moment with the state?
Okay.
Your Honor, on 19 MM 3734, the offer is 1 year jail. And on 19 MM 3756, on count 1 will be a consecutive 1 year jail. And on count 2 will be a concurrent 1 year for that count.
Okay, all right. Is that the state's understanding?
Correct. Yes, Judge.
Okay, so it's no longer a plea to the bench. Mr. Garrity is taking the offer from the state. Is that right, Mr. Garrity?
Well, we originally planned to take the plea from the bench. That's what I'd rather do, because that's what we plan to do if my public defender says it's okay.
It's up to you, Mr. Garrity, as I
Yeah,
told you
the
yesterday.
plea like we originally planned, really.
But it may subject you to more time than what we talked.
Well, no, then, I don't really want that. Then I'll take the 2 years and I'd like to say I'm sorry. I was just trying to make up to my mother.
Don't worry,
for
Mr.
the phone-
Garrity, the
about the phone
judge will
calls.
give you time to talk to the court.
Yes, thank you.
Okay, I'll give you an opportunity to be heard momentarily. I just want to make sure all parties are on the same page with regard to the plea agreement.
I'm not sure if the victim would like to be heard, but.
She'll be able to be heard, certainly. Let's see, Ms. Paccarari will be able to be heard in just a few minutes. Okay, Mr. Garrity's been placed under oath. Mr. Garrity, you understand that, I've already asked some of these questions, but we're going to begin again, given the developments. Do you understand that in each case, by entering a plea of no contest, you're giving up your right to have a jury trial?
Yes,
If not a United States citizen, do you understand these pleas will subject you to deportation?
yes,
Under the influence today of any drugs, alcohol, or medication?
no,
Has anyone made any threats to persuade you to plea?
no,
Do you understand that you have the right to a jury trial where the state would have to prove guilt beyond all reasonable doubt to a unanimous jury?
yes,
And by entering these pleas, you're giving up that right. You understand that?
yes.
Okay, I want to turn first of all to case 2019 MM3734 with an alleged offense date of October 15th, 2019. State, do you have a factual basis?
You said 3734, Your Honor?
Yes?
On October 15th of 2019,
Use that microphone if you would, that way
yes,
everyone...
sorry. The victim, Ms. Procurari, advised that her son, whom she has an injunction against and was served on 10/14, called her and left her a voicemail telling her that he was sorry and he wanted to reconcile with her. All of these events occurred in Osceola County, Florida.
And there's an element that deals with the fact that at the time of the communication, there was a, let's see the information. I might have missed you saying it, but the allegation involves violation of a domestic violence injunction. So was there an injunction in place at the time?
Correct, yes, Your Honor. The injunction in place was 2019 DR 2410, and he was served on October 14th of 2019, and this event occurred on October 15th of 2019.
Okay, and then I'm going to go ahead and entertain a factual basis for 19 MM 3756, if you have that.
Yes, Your Honor. On October 21st of 2019, the victim had in place an injunction, which was 2019 DR 4210, which the defendant was served with on October 14th of 2019, as well as a no contact order for 2019 MM 3734. Victim advised that on this date, the 21st of October of 2019, the defendant called her from the Osceola County Jail. All of these events occurred in Osceola County, Florida.
Based on the state's recital of facts, coupled with my own prior review of material portions of the police reports, Mr. Garrity, I accept your pleas of no contest in each of these cases to each of the counts. Before proceeding to the agreed upon sentence, I want to afford the opportunity for the parties to be heard. Mr. Garrity, did you wish to say anything before imposition of sentence?
Yes, I'd like to, I'm sorry, and I regret the violations. I was trying to make up with my mother. That is the reason why I made the 2 phone calls. I had bad headaches, and I was on the street homeless, and that's why I was just trying to get home. I'm sorry.
All right. Ms. Paccarelli, did you wish to be heard today? Is Ms. Paccarelli on the phone?
Yes, I'm here.
Okay, Ms. Paccarelli, this is Judge Epperson, and you have the right to be heard today before the court imposes sentence because you're the victim in this case. Ms. Castro, were you going to ask questions or just allow her, or did she wish to just speak in a narrative form?
Just to speak in a narrative form, I spoke to her yesterday and she did express that she wanted to address the court.
All right, Ms. Paccarelli, if you could address the court. Now's the time.
I'm here. I'm sorry, I'm sick. I'm not too with it.
Was there anything you wanted to tell the court?
What I just say what I had to say?
Yes.
Hello?
Yes. Now is your time to speak to the court about these matters.
Hello?
Hello, I'm here.
I need to. Ms. Paccarelli, this is Judge Epperson. Is there anything you'd like to tell the court today?
Yeah, I would like the maximum sentence. The reason I did the injunction is because he was living with me, and I do love my son, but I can't live in fear anymore, and he is sleeping with my door locked. He has threatened me that I'd wind up like his father, and he's called me names and stuff, and I can't live like that anymore. And my house is sold, and I'm trying to get into an apartment, so I want the maximum sentence.
All right, Ms. Paccarelli, thank you for appearing today. I heard everything that you just said, and it's important that you express your thoughts about the case.
Thank you.
All right, thank you, ma'am. Keep on the line. All right, with respect to case 19MM3734, violation of a domestic violence injunction.
Your Honor, if I may be heard.
Okay.
Emily Jimenez for the record. The reason that I provided the court some documentation is because when the client was released from the OC, he was instructed, and when they were talking to him, they said that that was the address that he was going to be released. I'm not stating anything about that conversation that happened. This is just a statement that the client has made to me, and I requested the documentation from the jail that the prison where he was staying, and they actually released these documents. And on the release address on the third page, it states the address and the name of the mother. That is why the defendant went there. So at some point, he was following the instructions on his release from prison. That is why we are asking the court to, now that we're just accepting the offer from the state, for the court to maintain our offer, accept the plea agreement between the parties. The client was just complying with the instructions that he was given. He changed his life. He has become a Christian. He wanted just to seek forgiveness. And that's why he was trying to contact his mother. He was just trying to say, I'm sorry, that he apologized, and that that's all he was looking for. He's a changed man. Every time we have conversations, he's talking and giving me verse of the Bible and talking to me about other stuff that the court is not the essence at this point. Based on the information that I have with my client, I think that all he was seeking was to have just the opportunity to say I'm sorry to his mother, which he's having it right now. So I'm hoping that this doesn't happen again. But since the client already had the opportunity to say I'm sorry, that was all he was seeking. And I just wanted to provide the court the reason for the client to try to contact the mother. And it was just to say I'm sorry.
All right, turning to case 19MM3734, having accepted the plea of no contest to violation of a domestic violence injunction, I will adjudicate Mr. Garrity guilty of the offense, sentenced to 365 days in the Osceola County Jail with credit for the 252 days that's already been served. There are court costs in the amount of $273. There is a $100 cost for the services of the public defender and a 201 domestic violence surcharge for a grand total of $574. Mr. Garrity, you must report to the Osceola County Clerk of Courts Collections Department within 5 days of your release from custody for the purpose of making a monthly payment plan for this obligation. Also, you're not to have any contact with Ms. Judy Paccarelli. You have 30 days to appeal the judgment and sentence of the court. Turning next to case 19MM3756, I accept your plea of no contest to count 1, violation of a domestic violence injunction, adjudicate you guilty, sentence to 365 days in the Osceola County Jail with credit for the 249 days that you've already served. This sentence runs consecutive to the sentence in 19 MM 3734. With respect to count 2, violation of a pretrial release condition, I will adjudicate you guilty, having accepted your plea of no contest, sentence you to 365 days in the Osceola County Jail with credit for the 249 days that you've already served. This count 2, runs concurrent with count 1, but consecutive to case 19 MM 3734. There's mandatory court cost of $273, a $100 cost for the services of the public defender, a 201 domestic violence surcharge, for a grand total of $574. You must report to the clerk of court's collections department within 5 days of release for the purpose of making a monthly payment plan, and you're to have no contact whatsoever with Ms. Judy Paccarari. You have 30 days to appeal the judgment and sentence of the court. Was there anything else from the state or defense?
No, Your Honor.
All right, Mr. Garrity, did you fully understand all of that?
Yes?
All right. And again, thank you, Ms. Paccarari. That concludes these matters. Thank you.
Thank you.
Thank you. All right. Ms. Castro, did you have any other matters? Okay, how about Anwar Feliciano Morales? Is that one? Let's deal with that case then. Anwar Feliciano Morales, who I believe is at the jail? Or maybe we needed to do the quarantine, folks. I'll just let corrections. I don't want to interfere with some quarantine protocols you're following, so if corrections can just have the folks that are there come up one at a time. All right, sir, your name?
Justin James Capana.
Okay. Capana, was that 38 or? 20 MM 874, Justin Capana. Mr. Klein is counsel of record, and I don't see him here. Your attorney's not here, Mr. Capana. It's set for a plea.
At 11 o'clock.
Yes, sir.
Oh, it's set at 11. See, I was, just so everyone knows, and I mean by that corrections, I was asked to call Mr. Capana's case last today because of the quarantine situation. And his attorney's not here because he's not set until 11 o'clock. We have a bunch of matters set at 10, but Mr. Capana's not set till 11. Let's see who else is at 11. Markel Gerardo is also at 11. So those two folks I can't take up till 11 because their lawyers aren't going to be here till 11.
Yes, sir, Your Honor.
I do have a 10 o'clock docket, which I'm ready to move with, but I also want to cooperate with you there at corrections. Do I need to give you all a few minutes?
Yes, sir, just to get these out.
Okay, we'll be in a brief recess, and if y'all can give me an indication you're ready to go. I hope you have the same docket I have. We have a number of matters at 10 o'clock that need to be called up.
Yes, sir.
All right, thank you, sir. We'll be in recess.
We had to send him back out real quick.
Okay,
So
all right.
he is on his way. We do have one non-quarantine individual up here.
Okay, who's that?
Marquel Gerardo.
Yes, and that's going to be a Teams meeting, so I'll come to that shortly.
But when you put, you need to put Stephen McLean district. Mr. McLean, isn't Mr. McLean the one that his son?
Yeah, yeah. Yep,
Weird. You know, okay, I'm gonna fight.
yeah. I don't know if you heard, but they're bringing him back. He was here earlier. Yeah. Ms. Jones is going to be bringing my laptop. And whoever has the Gerardo matter, which is with Ms. Carestes, it's going to be a Teams, and so you might have to use your room there to avoid the microphone disasters.
May we address a case? It's the last case of.
No.
Oh, I'm sorry. No, we don't get paid on annual.
Hang on just a minute, 2 minutes.
She's just setting up.
Is this your client, Mr. Klein? Is this Mr. Campana?
Yes, sir.
All right, Mr. Campana, please raise your right hand to be sworn.
Yes, sir.
Do you solemnly swear or affirm that the testimony you shall give to be the truth, whole truth, and nothing but the truth, so help you God?
Yes, ma'am. Yes, sir.
All right, you can put your hand down. Mr. Klein?
Your Honor, John Klein on behalf of Justin Capana, we've reached a negotiated plea agreement with the state. The terms are the plea, it would be a plea of no contest as charged, and the agreed upon resolution would be an adjudication of guilt. 84 days in the Osceola County Jail with credit for 84 days time served. Court costs, cost of prosecution, and cost of defense.
There's no cost of prosecution, Your Honor.
Okay, even better.
Mr. Capana?
Yes, sir.
Do you understand that by entering a plea of no contest to the charge of resisting an officer without violence, that you're giving up your right to have a jury trial?
Yes, sir.
Do you understand that if you're not a United States citizen, this plea would subject you to deportation?
Yes, sir.
Are you today under the influence of any drugs, alcohol, or medication?
No, sir.
Has anyone made any promises or threats to persuade you to enter this plea?
No, sir.
Understanding these rights and consequences, do you wish to enter a plea of no contest to resisting a law enforcement officer without violence?
Yes, sir.
State have a factual basis?
Yes, Judge. On April 3rd of 2020, law enforcement officers in Osceola County arrived at the defendant's home to execute an arrest warrant. When they got there, they knocked on the door and were able to identify the defendant through the window. When the defendant did not open the door to their lawful commands, law enforcement kicked in the door and made the arrest.
Who was the warrant for?
Him.
All right. Defense willing to stipulate to a factual basis?
Yes, Your Honor.
I accept the plea of no contest, Mr. Capana, to resisting an officer without violence. Adjudicate you guilty, sentenced to 84 days in the Osceola County Jail with credit for the 84 days that you've already served. There are court costs of $273. I'll order that you pay this within 90 days of your release from custody. That's payable to the Osceola County Clerk of Court. You have 30 days to appeal the judgment and sentence of the court. Okay, and of course, counsel was appointed in this matter, and so in addition to the $273 in cost, the court would assess $100 cost for the services of legal counsel. So the grand total is $373, and again, you must pay that within 90 days of your release to Osceola County Clerk of Court. You have 30 days to appeal, and you'll be released on this case today, subject to any other holds that you might have. Did you fully understand all of this?
Yes, sir.
All right, there'll be a fingerprinting in this matter, of course. Anything else from either side?
No, Your Honor, we thank the court and the state.
All right, thank you very much.
Have a good day.
That concludes this matter. All right, I do have, Ms. Jimenez, thank you, Mr. Klein. You mentioned, good to see you. You missed something with, mentioned a case with Ms. Castro. Is that going to be a plea?
It's a motion to continue, maybe a plea certain. The case is set, I'm trying to look it up.
Just tell me which case it is.
Lemuel Cruz, 20 MM 899.
Your Honor, this case was set to, Evelyn Jimenez for the record. This case was set to plea.
I'm out. I'm out. Yeah, it's not.
Okay, so the case was on the docket because it was on pretrial conference. He was set yesterday for plea before Judge Wooden on a global plea. That's why I was looking for it, because on the original docket, he was set there.
I'm out.
Yeah.
I'm not going to do this right now. I've got an 11 o'clock Teams meeting. I'm going to do that case now. All right. Thank you. Just a minute. So who from the state has the Gerardo or Markel Gerardo?
Alex Card for this.
Okay, I'm getting ready to do the Teams thing.
Okay, great. I'm going to go to the other room.
All right, thank you. So we're going to let her in. Hello there. Let's see, let me turn my volume up. Okay, Ms. Carestes, can I be heard?
Yes.
Okay, in just a moment, Mr. Card will be joining us from the State Attorney's Office. Just one moment. Is Markel Gerardo in the jail room? He can come forward if he is. Okay, he is coming forward and he is in view and he's now at the microphone. Just a minute, Mr. Gerardo. Your attorney is here by way of, I'll call it teleconference, and we're just waiting for the prosecutor to join us. Should be happening shortly. See if I can, I'm going to minimize this to see if I can need to invite him in.
I'll look at that motion.
Let me admit Mr. Card. There we go. Okay, we're all now viewable. Mr. Card, can you hear and see what's taking place?
Yes, I can.
Very good. Let me get the microphone over here so the record is clear. So as we move forward, if each of you could speak up to make sure that our court reporter is getting the matter down. Okay, so this is 2020 MM572. Mr. Gerardo is before the court at the jail, and we're here for pretrial conference on a trespass charge. Ms. Carestes?
Yes, Your Honor. I was just appointed on this case about a week ago. Mr. Gerardo has been in jail longer than the maximum penalty for the case, but he does have other serious felonies pending, so I would not imagine that pleading to this case will result in his release.
I tried to set up a video conference with Mr. Gerardo yesterday, but it was unsuccessful, and the next time I can speak to him is Friday afternoon. If Mr. Gerardo is interested in entering a plea, I don't see that it would negatively impact him, but if he prefers for me to speak to him first, then I just ask that this case be remain on for trial, or you do whatever it is that you're doing with cases right now.
Mr. Gerardo, did you hear all of that?
Yes, Your Honor.
It's up to you whether you wish to enter a plea today. If you did enter a plea, it would be a credit for time served sentence, and you'd be released on this case today, subject to any other holds. Or I could put your case on the trial docket. It's up to you, and your attorney is here if you needed to have any consultations about that.
I'd like to talk to him.
I couldn't hear you?
I'd like to talk to him.
Okay, he would like to have further consultations with you, and if those are going to be private consultations, obviously it could not be done in this format. I'm also willing to allow some consultation right here and now if the parties were comfortable with that. It's up to you.
Judge, I have set up another video consultation for him on Friday afternoon at 3:20.
Okay.
So if the court wants to set a status or something for next week.
Okay. Let's set this for a status hearing. Let's set it out about 10 days. If we have a place on our docket, we can jam that in. It shouldn't be a lengthy hearing. So today's date is June 25th. If we could set that out 7 to 10 days. I know we're probably already populated with cases, but we could work it in. Just a moment. Okay. Madam Clerk's just checking our docket to make sure that we act prudently.
Judge, we can set it July the 9th, which is 2 weeks away.
Mm-hmm.
Or
July 9th at 10 a.m. for status. July 9th at 10 a.m.
That works for me, Judge.
Okay, this case will be set for status hearing at that time. Mr. Gerardo, did you hear and understand all of this?
Yes, Your Honor.
Okay, so you're apparently going to have a consultation with your lawyer in a few days about this matter and perhaps other matters.
Judge, if this will be a plea, should I go to the jail and be with him or come to the courtroom, or how should we facilitate that?
Well, it would need to be beginning next Monday. We're going to be kind of regressing back into what we call phase 1, and I cannot do in-person hearings. So it would have to be done virtually. You would need to communicate with the jail about how that might be done safely, but I could not have you come in here into the courtroom. It is possible, as long as you're okay with it and your client is okay with it, that perhaps you could appear virtually, and maybe we could do the video setup with your client as we're doing today.
Okay.
Okay?
All right, I'll work on that.
Yeah.
Thank you, Judge.
All right, thank you. That concludes this matter. All right. Thank you. Thanks. All right, I'll go ahead and end this. So that is that. I think everything but Bartley. Okay. Is Mr. Bartley, that was the last one. I think we've, is there anyone sitting in the jail room there that we've not handled yet?
Mr. Morales?
Okay, I don't see him on the docket, but let's do a double check.
I got a case number if you need that, Your Honor.
Yes.
It's, You seen him this morning? I'm sorry, Your Honor. He said he already saw you this morning.
Okay, okay.
Okay,
So
I guess it would be Bartley.
Bartley's the only one, so as soon as you can safely get him in there and let me know when we're ready.
Yes, sir.
We'll be in a brief recess, and then I'll let you put that on the record when he's here. Okay, we have one final matter, and I'm going to need to go back to your screen on Benchmark and pull up that conditional release order. Thanks. Hello, Mr. Bartley. Just a moment. Case 2019 MM3486, State of Florida versus Blaine Bartley. Mr. Bartley is before the court, along with counsel, Mr. Black for the defense and Ms. Janigian for the state. We're here for a competency status hearing. And just to put a matter or two on the record, Mr. Bartley, the reason you're in custody, you were set for a status hearing back on June the 24th. Correction, you were supposed to be here for a status hearing back on June the 8th, but you weren't here, you didn't show up. You failed to appear. And so the court issued a capias, and you've been arrested on that warrant. I did ask that you be brought before the court within 24 hours, and so here you are. Mr. Black, did you want to be heard?
Yes, Your Honor.
Using the microphone, yeah.
I do want to reiterate all the arguments I made earlier, and then I just literally received an email from his Orange County attorney. Apparently he's got an open case in Orange County, and they had a competency status hearing this morning as well, and she just informed me that that judge ordered another evaluation.
Oh.
So I don't know if you want to just track that case or if we want to order our own.
Yeah, I would rather track the case. Do you have that case number?
Yes, Your Honor. It's 20MM3641 in Orange County.
20MM.
3641.
Okay. Ms. Janigian, did you wish to be heard for the state?
No, Your Honor.
Okay.
Other than I'm fine with tracking the Orange County case so we don't duplicate resources.
Mr. Bartley, back on April the 28th, I know that's going back a few months, but I released you from custody and ordered that you report to Park Place within 48 hours. Did you do that?
Yes, sir. Yes, sir.
What happened?
She told me to sign some papers and they let me go.
Okay. And does the state or defense wish to be heard on the issue of the defendant's custody?
I mean, defense would ask that he be released from custody with conditions. He did, according to him, he reported to Park Place last time, and we would just ask that he be released because he is incompetent.
Anything, state?
I'm just worried for him showing up to his next competency evaluation, so I just register that objection.
Okay. All right, Mr. Bartley, for this case, you'll be placed on conditional release. You'll be released on this case today, subject to any other holds with the following conditions. You're to have no unsupervised contact with any minors. You must show up for your doctor's appointment or your evaluation in case number 20MM3641. That's the Orange County case, because the court will be relying upon the evaluations done in that case for this case as well, pursuant to the administrative orders that we have. Also, you must not consume or possess any alcoholic beverages or ingest any controlled substances unless you have a prescription, and you must take all prescribed medications that you might have and cooperate with any treatment that is in place for you. Anything else from the state or defense?
From defense, Your Honor, it's not really regarding his case. I just want to ask him if there's a phone number that we can reach him at.
Your attorney would like to have your phone number.
Yes, 321-202. 407-758-1728.
Can you say that a little slower, please?
407-758-1728.
And is that your personal phone?
That's my mom number.
1728?
Mm-hmm.
Okay.
My number 1-863-634-5259.
Just repeat that one more time. Sorry.
1-863-634-5259.
And are you done?
So what were you going to say?
Well, in this case, I want to set it for a status hearing. I'll set it for early September on the following date and time.
September the 4th at 9:30.
Okay.
And Mr. Bartley, where should we send notice to you for this hearing? What address?
10 Trophy Lane.
10 Trophy Lane. Is that the one we currently have? Let's check. Let's see. Yeah, 10 Trophy Lane, Poinciana, Florida, 34759? Okay, sir, just make sure you show up for any hearings that you receive notice for.
Okay.
All right, you'll be released on this today. Thank you.
Thank you.
Okay. I believe that's a wrap. You don't have anyone else there, right?
That's it.
All right, appreciate your help. Thank you.
you.
Right, we're in recess.
Okay, we'll go ahead and start then. We'll call the interpreter first.
Good afternoon, Your Honor. This is Carlos Morales, State Certified Spanish Court Interpreter. Interpreter has already been sworn in today.
All right, good afternoon, Mr. Morales. We are here at this time for initial appearances, so the folks you'll be interpreting for will not have the headsets. And before we proceed, let me just make a general announcement that I'd like you to interpret for the room there, if you would. Folks, you're here because you've been taken into custody at the Osceola County Jail.
Ustedes se encuentran aquí porque han sido arrestados y llevados a la cárcel del condado de Osceola.
I have read the arrest affidavits and arrest warrants in your cases.
Ya he leído los affidavits de arresto y affidavits de órdenes de arresto.
Unless I indicate otherwise, when your case is called, I do find probable cause to believe that you committed the crimes for which you've been arrested.
Y a menos que yo indique lo contrario, yo he determinado que hay motivo fundado para creer que han cometido los delitos de los que se le están acusando.
Each one of you has the right to be represented by a lawyer.
Cada uno de ustedes tiene el derecho a ser representado por un abogado.
And unless you inform me that you have private counsel, I will be appointing the Office of the Public Defender to represent you in each of your cases today.
A menos que me digan que tienen un abogado particular contratado, estaré nombrándoles a la Oficina de los Defensores Públicos para que lo representen en los casos que tienen ustedes.
As was stated on the video, you do have the right to remain silent.
Como escucharon en el video, tienen el derecho a guardar silencio.
You don't have to say anything about the facts of your case.
No tienen que dar detalles sobre ningún detalle sobre su caso.
I'm not going to be asking you about the facts of the case today, and we are not going to determine whether you're guilty or not guilty of the charges against you today.
Y yo tampoco le estaré pidiendo detalles sobre su caso, y el día de hoy no estamos aquí para determinar si usted es culpable o inocente de esas acusaciones.
It's very important for you to keep in mind that if you say anything about the facts of your case to any person other than your lawyer, it could be used against you later if your case goes to trial.
Es muy importante que recuerden, si ustedes hablan sobre los detalles o hechos en sus casos y se lo comentan a cualquier otra persona que no sea su abogado, puede ser usado en contra de ustedes más adelante en un juicio.
If you please come forward, Omar Rivera Marcano.
Omar Rivera Marcano.
This is case number 20MM1500. Please tell us your name, sir.
¿Cómo se llama usted?
Omar Rivera Marcano.
Omar Rivera Marcano.
Mr. Rivera Marcano, you were arrested on charge of battery.
Señor Marcano, usted fue arrestado por la acusación de agresión.
Your bond was set at $0.
No se le había asignado fianza.
Does pretrial release have any prior criminal history?
Yes, Your Honor. He has 9 priors dating back to 2012. The most relevant is a battery domestic in 2013, which was dropped, ag battery in 2015, unknown disposition on that, battery domestic in 2016, no action taken, and an aggravated stalking in 2019, which was no info. He also has a couple violations of no contact orders in 2016 and 2019. He was convicted of the one in 2019.
All right, Mr. Rivera Marcano, you do not qualify for direct pretrial release due to the nature of the charge against you.
Señor Rivera Marcano, usted no reúne los requisitos para poder salir bajo el Departamento de Libertad Provisional debido a la naturaleza de los cargos.
However, based on the facts of the case, I'm going to set bond in the amount of $100.
Sin embargo, tomando en cuenta los detalles del caso, voy a asignarle una fianza de $100.
That will be conditioned upon supervision by pretrial release.
I'm sorry, Your Honor.
That will be conditioned upon supervision by pretrial release.
Pero habrá una condición sobre eso que debe ser supervisado por el Departamento de Libertad Provisional.
If you do post bond, you will not return to the area of 931 Delano Court in Kissimmee.
Si es que usted logra salir pagando una fianza, le está prohibido regresar al 931 Delano Court en Kissimmee.
You may return on one occasion to retrieve any personal property or belongings you have at that address, accompanied by a law enforcement officer.
Sin embargo, si usted tiene artículos personales o pertenencias ahí, se le permite regresar una vez acompañado de un policía o guardia para poder recoger esas cosas.
You will not have contact until further order of the court with Lourdes Martirone Padilla.
Y le está prohibido tener contacto con Lourdes Martirone Padilla hasta nuevo aviso por parte de un juez.
You will not possess any weapons or firearms.
Y le está prohibido poseer armas o armas de fuego.
As I said, the public defender's office is appointed to represent you.
Y como ya dije, se le ha nombrado a los defensores públicos para que lo representen.
If you wish to return or have contact with Ms. Martirone Padilla, that may be able to be accomplished, but you need to work through your attorney.
Si es que usted desea regresar a ese lugar o desea tener contacto con la señora Lourdes Martirone Padilla, quizás sea posible, pero eso lo tendrá que averiguar a través de su abogado.
Unless those conditions are modified by the court, you cannot return or have contact.
Y le está prohibido regresar a esos lugares o tener contacto con ella a menos que lo modifique primero un juez.
Your Honor, we would ask for no hostile contact or some type of third party because there are children involved, so at least he'd be able to see his children or have contact with them without violating.
I would just ask for no contact now until we make contact with the victim.
I'm going to order no contact at this point. But again, that's subject to modification, so I'm sure the judge who's handling the case with more information may allow contact.
I'm sorry, Honor, the interpreter just heard I will order no contact, and after
Yeah, I
that,
said, the judge who will be handling this case may very well allow contact, but they'll need some additional information and some input from the alleged victim.
okay. Bueno, yo voy a imponer, como ya dije, que está prohibido el contacto con la persona nombrada. El juez que estará a cargo del caso quizás le permite tener contacto, pero primero se necesita más información de parte de la víctima. A menos que se cambie por orden del juez, le está prohibido el contacto con esa persona.
Mr. Rivera Marcano, your next court date will be
If still in jail, July 2nd. If filed, July 20th in courtroom 4A at 9 a.m.
Señor Marcano, la próxima vista que tendrá será el 2 de julio, si es que todavía está en la cárcel, y si ha logrado salir, será el 20 de julio en la sala 4A a las 9 de la mañana.
Thank you, sir.
Gracias.
Does anyone else present in the courtroom there at this time require the services of the Spanish language interpreter? If so, please come forward.
Your Honor, I believe that Daniel Montiel Castillo, okay.
Thank you, Mr. Morales.
You're welcome, Your Honor. Thank you.
Did he bond?
We had several that are in the hospital, and that would include Daniel Montiel Castillo, Jacques Nicholson, Kendall Colon, and Lou Stevens, as well as Elick Williams.
It's my understanding that Williams was returned this morning to the jail.
They told that he's not. So all of those will be reset when they are available to be seen. And the public defender's office is appointed at this time in all those cases.
Thank you, Your Honor.
All right, Raymond Delgado. Good afternoon, sir. Please tell us your name.
Raymond Delgado, sir.
Mr. Delgado, you arrested on a warrant for violation of community control in case 13 CF 915 on a charge of robbery with a deadly weapon. Your bond is set at 0 at this time. The public defender's office has been appointed. Your next court date will be?
Next court date, July 29th in courtroom 4F at 9 a.m.
Thank you, sir.
Oh, and Judge, his attorney record is Roberts.
Robert
Blain.
Slatkin? Okay. He's filed an NOA. Okay, so the public defender's office is withdrawn their previous appointment. Clayton Griffin.
Your Honor, we would ask to reset this case. There's possible conflicts in our office. Can we reset this for tomorrow?
Okay, I'll address him today and we can recall it tomorrow.
Thank you.
State your name, sir.
Clayton Griffin.
Mr. Griffin, you were arrested on a warrant and have subsequently been charged by information in case 20 CF 1636 with kidnapping with intent to commit a felony with a firearm in count 1, robbery with a firearm in count 2, grand theft in count 3, fraudulent use of personal identification information in count 4, and unlawful possession of a stolen credit or debit card in count 5. The charges that were filed are somewhat different than the charges in the arrest warrant, so I'll clarify the bonds, which will be as follows. Bond will be 0 for counts 1 and 2, be $1,000 for counts 3, 4, and 5. The public defender's office is appointed to represent you, but they apparently will have a conflict because they represent one or more co-defendants, I guess, or perhaps a victim, alleged victim. So we'll call your case back tomorrow if they've made that final. Have you made the final determination that you? Okay.
Not yet, Your Honor.
They're going to be deciding whether they have a conflict that will require them to withdraw. We'll call your case back tomorrow. If they are withdrawing, I'll appoint another lawyer to represent you. Your next court date in this case will be, should have an arraignment. Just one moment.
Next court date, July 6th in courtroom 5F at 8:15 a.m.
So we'll see you tomorrow, and then we'll see you July 6th. Thank you. Joshua Bermudez Garcia. All right, state your name, please.
Joshua Bermuda.
Bermudez, you were arrested on charge of battery. Your bond was set at 0. Do we have any information on Mr. Bermudez? Well, I see he's out on probation and out on, has cases pending in drug court.
Yes, Your Honor.
All right, Mr. Bermudez, I'm going to set bond in this case in the amount of $500. It will be conditioned upon supervision by pretrial release if you are released. And it will be a condition that you not have contact directly or indirectly with Julie Morales. You will not go to within 1,000 feet of any residence where you know her to be staying or any place of employment as you may have or any other place that you know her to be. You are out on probation, I'm informed, in case 19 CF 1283. And based on this arrest, I do find a basis to believe that you did willfully violate your probation in that case. So you'll be held without bond until further order of the court in that case. You're also currently in drug court with Judge Whitehead in cases 19 MM 1088 and 19 CF 1283. That is the DOP case. So I'll revoke any bond that may exist in case 19 MM 1088 in order to be held without bond pending further order of the court in that case. The Public Defender's Office has been appointed to represent you, Mr. Bermudez. Your next court date will be?
Next court date, if still in jail, July 2nd, if filed July 20th, in court 5B at 10:30 a.m.
Thank you, sir.
And Your Honor, due to the fact that he has the open cases, he does not qualify for CPR.
Okay, well, it'll be conditions of the bond, not pretrial release. Thank you. Rohan Buck. State your name, sir.
Rohan Buck.
Mr. Buck, you're arrested on a charge of petty theft. Your bond was set at $1,000. I see he qualifies for pretrial release. Do we have any prior history?
He has no convictions. He had a battery domestic in 2016.
If he has no convictions, that's fine. Okay. All right, Mr. Buck, I'm going to release you on pretrial release in this case. That being the case, since you're going to be released from jail, I'm not going to appoint a lawyer to represent you at this time. At your next court date, if you're unable to afford to hire a lawyer, you can fill out an affidavit. We don't have any affidavits, do we, that have been completed? I mean, they haven't filled them out. Okay. So at your next court date, you can fill out an affidavit of insolvency. If you cannot afford to hire a lawyer, the judge at that time will appoint a lawyer to represent you. If you're able to hire a lawyer, that's fine as well. Your next court date will be?
Next court date, July 20th, in courtroom 5B at 10:30 a.m.
So you need to appear on July 20th at 8:30 p.m. in courtroom 5B, 10:30 a.m. in courtroom 5B. And if you lose track of that, the pretrial release will always have the information about your next court date. All right. Thank you, sir. Julio Chiclana. State your name, please.
Julio Chiclana.
Mr. Chiclana, you were arrested on a charge of battery. Your bond was set at 0. Do we have any prior history on Mr. Chiclana?
He has no history, Your Honor.
All right. Mr. Chiclana, you don't qualify for direct pretrial release, but I will set bond the amount of $100. It will be conditioned upon supervision by pretrial release. Mr. Chiclana, you're going to have to find another place to stay on a temporary basis. So you can be able to do that?
Yes.
Okay. I'm going to order that until further order of the court that you not return to the residence at 2261 Canyon Breeze Avenue. You may return on one occasion accompanied by a law enforcement officer to retrieve clothing or personal possessions you may need from that address. The condition of your pretrial release that until further order of the court, you are not to have contact with Marie Nieves Flores. You will not possess or consume any alcoholic beverages or any controlled substance without a valid prescription. You will not possess any weapons or firearms. Now, those conditions can be modified. Talk to your lawyer if you want to return, if you want to have contact. That may very well be possible, but it cannot be done even if the alleged victim wants to have contact with you. You cannot allow that to occur until the court modifies the conditions of your release. If you were to do so, you'd be violating conditions of release. You could be held in jail without bond until the case is resolved. So if you want to have contact, if you want to return, talk to your attorney. They can schedule a matter before the court to be handling the case.
Your Honor, we would ask that the condition of no alcohol will not be part of his release conditions because the affidavit does state that alcohol does not appear to be a factor in this incident.
Okay, I may have been conflating this one with another case. All right, I don't see any reference to alcohol or drugs, so I'll delete the no alcohol requirement. Mr. Chicana, your next court date will be?
It's still in jail July 2nd, if out July 21st in courtroom 5B at 9:30 a.m.
Thank you, sir. Yes. John Hatchell, did you wish to waive the reading of the charges?
Oh, we actually would like to address this towards the
Sorry?
end. Can we address this towards the end?
Okay, Mr. Hatchell, your attorney's asked that we call your case a little bit later, so you'll just have a seat. We'll call you back in a little bit.
Thank you, Your
Thank
Honor.
you. William Rivas? State your name, please.
William Rivas.
Mr. Rivas, you arrested for possession of heroin and possession of drug paraphernalia. Your bond is presently set in a total amount of $2,000. You do appear to meet the criteria for pretrial release. Any prior history?
Yes, Your Honor. He has 8 Florida priors between the years of 2010 to 2014.
Anything since 2014?
No, Your Honor.
All right.
Judge, and the state does not object to him being released ROR.
I'm not going to release him ROR, but I will release you on pretrial release, Mr. Rivas. That will be conditioned upon you not possessing or consuming any alcoholic beverages or any controlled substance without a valid prescription. You will be subject to random testing to make sure that you comply with that requirement. I'll go ahead and appoint the Office of the Public Defender to represent you. Your next court date will be on demand in circuit court, which means it will be scheduled after the state has determined what charges, formal charges, if any, they're going to file against you. All right, thank you, sir. Anthony Roman. All right, good afternoon, Mr. Roman. State your name, sir.
Anthony Roman.
Mr. Roman, you arrested in 2 matters. You arrested for possession of cocaine. The bond is set at $2,500 and possession of drug paraphernalia with a bond of $250. I'm going to reduce the bond on the possession of cocaine to $1,000. However, you were also arrested for a violation of probation on Orange County case 19 CF2797. You're being held without bond on that violation of probation. You're also it is Osceola. It's Osceola case, county case 19 CF2797. You're also out on bond in Osceola County case 19 CF3482. Based on this arrest, I will revoke and discharge the bond in that case, nor will you be held without bond pending further order by Judge Wooten in that case. The Public Defender's Office is appointed to represent you. Your next court date,
Next court date for 2020, CF 1794 on demand, and for 2019, CF 2797, July 1st in courtroom 5A at 8:45 a.m.
thank you, sir. Thurston Tharib. All right, good afternoon, sir. Tell us your name, please.
Thurston Tharib.
Mr. Tharib, you arrested on 3 different cases. You arrested for resisting an officer without violence. In case 20MM1501, your bond is $500 in that case. You're also arrested on a warrant for failure to appear for arraignment on a violation of probation in case 13CT4866. You have a bond of $2,000 in that case. You were also arrested for failure to appear for arraignment on a violation of probation in case 13CT4865. You have a bond of $2,000 in that case as well.
Sorry, I couldn't hear you, Your Honor.
I'm sorry?
I'm sorry, I couldn't hear that last statement, Your Honor.
You have a bond of $2,000 on each of the failure to appear warrants, $500 on the new charge, so your total bond is $2,500. The Public Defender's Office is appointed to represent you in these cases. Your next court date will be
Next court date for 2020, MM1501, if still in jail, July 2nd, if out July 20th in courtroom 4A at 10 a.m. Then for 2013, CT 4865 and 4866, if still in jail, July 2nd, if out July 20th in courtroom 4A at 8:15 p.m.
So you can talk to your attorney. You may be able to handle all of your cases at one time, but you can discuss that with your attorney, whether that's what you want to do.
Yeah, I mean, we reduced the FTA bonds and all those cases are quite old. Would there be a possibility of reducing in the 2000s? Okay.
Thank you, Mr. Tharib. Thank you, sir. That's all.
Oh, was that being reduced, Your Honor, or no?
I'm sorry?
Was that being reduced?
The bond was not reduced, no. The bond totals $2,500.
Is it 4,005?
$4,500, yes, thank you.
Would that be all, Your Honor?
Yes, sir. Have a good afternoon. Okay, that's all we have in this group except for Mr. Hatchell. So, John Hatchell.
Did everybody clear the jail?
There's only one other person there, but John Hatchell, come on up. So, good afternoon again, Mr. Hatchell. If you'll state your name.
John Hatchell.
Can we waive the reading of the charges?
Mr. Hatchell, you arrested in 2 cases on 6 total counts.
Right.
Do you understand what the charges are, sir?
Yes, sir.
Your bonds were set at 0. I find that you are entitled to bond being set.
On counts, on the sexual battery counts, the state's gonna argue that the defendant has a familial custodial relationship with the victim, so that would be punishable by life on that. So we would ask that he held no bond, based on the affidavit's proof evidence presumption grade.
Your Honor, we would say that this does not rise to the level of proof evident presumption grade. The only thing we have in the affidavit is a statement from the victim, and the age isn't even clear in the affidavit. There's no date of birth. We'd be asking for bond in this case.
There's a age listing in one, and both of them, actually. So even without the date of birth, I don't have any issue with respect to that. And as to proof evident presumption, great, if he is charged with a first-degree felony punishable by, or a felony punishable by up to life, the court finds that it's not required to make a proof evident presumption great determination at initial appearance. I know the district courts of appeal disagree as to that, but I don't think that's what the intent of the law is. We'll have to see what the Supreme Court says and decides. Well, at least as to the second-degree felonies, there are 3 of them. He is entitled to bond being set as to those. So as to the second-degree felonies, I will set bond in the amount of $10,000 each. The bond will be conditioned upon no contact whatsoever with the alleged victim or her siblings, no intentional contact with any child under the age of 18 without that child's parent or guardian being physically present. As to the 3 counts of sexual battery, I'm going to leave bond at 0 at this time. And, you file a motion for bond, and it'll be heard expeditiously if you file it. Do we know what division this is going to be in? Okay. So if you file a motion for bond, we could hear it as early as Monday.
Thank you.
So, Mr. Hatchell, the Public Defender's Office has been appointed to represent you in your cases. Your next court date will be on demand in circuit court, which means it'll be scheduled after the state has decided what formal charges, if any, they're going to file against you. If they don't file any formal charge against you within 30 days, you may be subject to, or may be entitled to release on your recognizance by the 33rd day. But your attorney can explain all that to you, and someone from the Public Defender's Office will be in touch with you very shortly. Thank you, sir. That's all. Thank you.
Judge, on Kendall Cologne, I believe he's in the hospital, right?
Yeah, we went through, there were a group of them that were in the hospital.
But the state filed a pretrial detention motion on him. I don't know if you want to just give us a date within the 5 days or.
Oh, I looked in the benchmark, I didn't see that a motion.
I filed it probably around 11:30, 12.
Sorry?
11:30, 12 o'clock, I filed it.
Okay, I just checked before I came downstairs, I didn't see it, but,
There you go.
okay, well, that's fine. Yeah, we can set that for hearing on the motion for pretrial detention on Mr. Cologne.
Your Honor, can we reset this? I think there's some arguments with this motion. There's some arguments with this motion, so can we reset this then for tomorrow?
We're not going to hear the motion today. I'm setting it, they filed it, I'm going to set it for hearing, you can make your arguments at that time.
We're not going to argue the actual substance of the case. We're just arguing it for the Arthur hearing period.
That could be made at the hearing.
Right. I'll set it for Monday, the 29th at 9 o'clock, and we'll hear whatever you want to be heard. You very well may not be available anyway tomorrow or Monday. We'll have to see. I'm sorry? Yes. On all the folks that are in the hospital, read the bonds I said. So you got all the names of the folks that were not going to be here? Yeah, Mr.
There's a Brittany Gardell.
We've got another group.
Oh, okay.
Your Honor, actually, I have one for the first group.
Who's that?
It's Levon Perkins.
He bonded.
Okay, thank you.
Bond has been posted, so
They tell us that. Thank you.
thank you.
That was the next.
So we've got three left. That's Jose Hermosan, Brittany Gardell, and Chelsea Ratliff. The ones that were in jail were, in the hospital were Daniel Montiel Castillo, Jacques Nicholson, Kendall Cologne, Lou Stevens, and Elick Williams. On all the folks in the hospital, I've appointed your office, and we'll just have them brought back to IAs when they're Good afternoon. Tell us your name, please.
Brittany Gardell.
Hey, Ms. Gardell, you arrested on a charge of battery. I've reviewed the affidavit for arrest warrant, or excuse me, the arrest affidavit. And quite frankly, I don't find probable cause based on that affidavit. So I'm going to release you at this time on your recognizance in this case. That doesn't necessarily mean the state will not be filing formal charges against you. They may do that, they may not. You receive your mail at 1813 Bronson Drive, Apartment A in Kissimmee?
Yes.
Okay, well, any further future court appearances will be sent to you at that address.
Okay.
I don't know what was going on. It looks like it was pretty wild scene. You just need to avoid that situation going forward.
I'm sorry?
You need to avoid that kind of situation going forward, or you'll be back in jail.
Okay.
Since this is a straight ROR, due to the inconsistent statements made by the alleged victim, there won't be any conditions. All right, Ms. Gardell, since you're being released, I'm not going to be appointing counsel to represent you. If you do have a future court proceeding in this case, and you cannot afford to hire a lawyer, one will be appointed to represent you at that hearing. All right? Thank you. Your next court is,
Next court date, July 21st, in courtroom 5B at 9:30 a.m.
so you need to report to court on July 21st. If you forget that date or don't know what date you're supposed to be here, call the clerk's office. They'll tell you what it is. All right? Thank you. All right, Jose Hermosan. State your name, please.
Jose Jamosi.
Mr. Jamosan, you were arrested on a warrant out of Orange County. This is for violation of probation for shooting or throwing a deadly missile at or into a building. Your bond is set at $0. So be held without bond at this time. The public defender's office is appointed to represent you. Right now, there's limited transportation between the jails. I don't know what the situation is at this moment between Orange and Osceola. So an attorney from the public defender's office will be in touch with you. It may-
There's a private attorney.
Oh, do you? Do you have an attorney?
Yes, Your Honor.
Who's your lawyer?
Carlos Payas.
Carlos Paz?
Yes, Your Honor.
Okay. Does he know you're in custody?
Yes, Your Honor. What happened was I bonded out, and they say that you cannot leave Osceola County because you have a warrant in Orange County, so I never got a chance to leave.
All right, but he knows you're in jail, so he'll know what steps to take going forward. All right,
Yes, Your Honor.
thank you, sir. All right, tell us your name, please.
Chelsea Ratliff.
Ms. Ratliff, you're here because you've been taken into custody on a warrant for violation of probation in case 19 CT 149 on the charge of driving while under the influence. Your bond was set at 0. It's going to remain at 0 at this time. The Office of the Public Defender is appointed to represent you. Do you have a lawyer?
I have a public defender, I think, for.
Okay, the Public Defender's Office is appointed to represent you. Your next court date will be,
Next court date, July 2nd, in courtroom 4E at 8:05 a.m.
so your next court date is on July 2nd. And your attorney will be in touch with you sometime before then. Thank you. Okay, we've got someone else back there.
I
Who
believe
else?
that's all we have for first appearance.
Okay, great. Are you covering the 2 o'clock?
I am not.
Austin? I thought it was worse than that. I told Kristen we have to get some dates. Okay,
Thank you, Your Honor.
thank you.
Have a good afternoon.
You too, thank you. Good to see you.
Have a good one, Judge.
Bye.
First appearance available, over. Have a female for Melanie.
Mark, it'll be at ease for just a moment while they're bringing folks in.
Yeah, I think that I would be willing to agree to the loss
I was hoping less than that, but let's see what happens.
Sure. The only reason I would say 25.
Do we have a record? I don't know if it's right.
Yeah, he does have a record.
So,
So,
yeah. Whatever you do.
sure, yeah. Let me go ahead and email you the score sheet.
Yes.
Certainly, perhaps put it downstairs, but I'm gonna go ahead and get that record.
Really? I think it's complicated.
Yes, yeah, it's UI, and Willis. The two open cases I saw previously. You're down to PR for that, and then I think they were both wrong. They were picked up for a specific charge that came in as a fact, and now it's dropped to a separate conversion. I'd be willing to go to a 25 for the
Huh? We're going back to phase one, right? We're backwards. So that means there's no more warrants. When? In what, 2 months? 2 months? No, I got guys in jail on me. I can't imagine doing a jury. Well, I don't know what, the jurors are not gonna want to be so many people.
All right, do we have Joel Brown? All right, good afternoon, sir. Please tell us your name.
Jeffrey Lynn Brown Jr.
Serena Hernandez, defense.
Ms. Brown, your lawyer had filed a motion for release on recognizance in case 20 CF 1494 due to the failure of the state to file a formal charging document against you within the time period provided by the rules of criminal procedure. The state has filed an information in this case prior to hearing on that motion, so the motion for ROR will be denied. You're charged in this case with possession of heroin in count 1 and possession of drug paraphernalia in count 2. Count 1 is a third-degree felony, which is punishable by up to 5 years state prison, up to 5 years probation, and/or a fine of up to $5,000. And count 2 is a misdemeanor, punishable by up to 1 year in the county jail, up to 1 year probation, and/or a fine of up to $1,000. Do you understand what the charges are, sir?
Yes, sir.
Not guilty, Your Honor.
We'll accept the plea of not guilty, and we'll set the case for the August 24th trial docket. Pre-trial will be August 12th, Mr. Brown. I'm sorry?
It's okay, Mr. Brown. We'll discuss that together.
I will clarify the bonds at this time. The bond will be $1,000, just count 1, $500 for count 2. And also, based on these charges, you may qualify for the state's drug diversion program or the drug court program. You can talk to Ms. Hernandez about those programs and whether you might be interested in either one. All right, thank you, sir. All right, we can, let's do Mr. Rivera. Alberto Rivera?
Gary Lentz on behalf of the state.
Hello, good afternoon.
Good afternoon, Mr. Rivera. Mr. Rivera is here on a motion to reduce bond, which seems appropriate. The original bond was based on charges that he's not been filed against him. He's got one count of possession of methamphetamine. So are you asking for the standard bond to be set?
Yes, Your Honor, and what would that amount be?
$1,000.
That's what I would be hoping for, Judge.
State, did you wish to be heard?
Yes, Your Honor. The state would be asking for the bond to be the $2,500 for possession of methamphetamine. It was the only count that was charged in this case, but it did come in as a trafficking. However, there was no defendant possessed of the bond, which is why he was
Okay. Well, based on the nature of the charge and the situation right now with the pandemic, I'm going to set the bond at $1,000. So, Mr. Rivera, your bond in this case is reduced to $1,000, and the case remains set on the August 24th trial docket.
That's great. And just for the record, Judge, I'm Luis Davila for Mr. Rivera.
Yes, thank you.
Thank you, Judge. Go ahead.
All right, thank you.
Thank you.
So, just to clarify, my new bond amount on this case and the other case, because I did have a misdemeanor case as well, is that a total of $1,000, or is the other case?
No, it's only this case. The misdemeanor case will be up to the county court judge, and I know they did revoke the outstanding
I
bond.
suspect they did, Judge, but I'm not involved in that case, at least not as of yet.
You need to talk to your attorney in the county court case before.
I understand. I'm scheduled June 30th for that case. Is that still going to be happening, or are the courthouses going to be closed?
Well, the courthouse will not be closed. Some hearings will be done remotely. If you're still in jail, you'll be seen like you are today. If you're out of jail, you need to talk to your attorney to see whether that hearing's going to take place as scheduled or whether it'll be reset.
I do. Thank you.
Thank you.
I appreciate it. Thank you, Mr. Davila.
Thank you, Judge.
All right, then we have Mr. Mena.
Gary Lentz on behalf of the state.
All right, do we have Joel Mena? That is it.
Sorry, can you repeat it? State of the bench. That's for a global resolution of the open cases and probably apparently isn't open VOP in Orange County as well. Okay. Yeah. Gunshot motor vehicle. Go ahead.
All right, Mr. Mena, good afternoon. If you'll raise your right hand. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
What is your name, sir?
Joel Mena.
Okay, Mr. Mena, Mr. Lopez is here on your behalf. Mr. Lopez, how are we proceeding today?
Yes, Your Honor, we're hoping to enter pleas on both cases, 2020 CF 417, 2017 CF 4165. We'll enter pleas of guilty on all counts on both informations. It's a plea to the bench at this point, Your Honor.
Thank you. All right, Mr. Mena, thank you. In case 20 CF 417, a plea form has been submitted which indicates you wish to enter pleas of guilty 2 possession of cocaine is charged in count 1, and 2 possession of drug paraphernalia is charged in count 2. Is that what you want to do in that case?
Yes.
Count 1 is a third-degree felony, which is punishable by up to 5 years state prison, up to 5 years probation, and/or a fine of up to $5,000. It also carries a mandatory 6-month driver's license suspension. Count 2 is a misdemeanor, punishable by up to 1 year in the county jail, up to 1 year probation, and/or a fine of up to $1,000. You understand, sir?
Yes.
In case 17 CF 4165, the plea form submitted indicates you wish to enter pleas of guilty to grand theft of a motor vehicle is charged in count 1. Burglary of a conveyance is charged in count 2. Conspiracy to commit burglary of a conveyance is charged in count 3. Grand theft is charged in count 4. And contributing to the delinquency or dependency of a minor as charged in count 5. Is that what you want to do in that case?
Yes.
Counts 1, 2, 3, and 4 are all third-degree felonies, which are punishable by up to 5 years state prison, up to 5 years probation, and/or fines of up to $5,000. Count 1 also carries a mandatory driver's license suspension for the period of any sentence the court may impose. Count 5 is a misdemeanor, which is punishable by up to 1 year in the county jail, up to 1 year probation, and/or a fine of up to $1,000. You understand?
Yes.
All right. Did you read and fully understand the written plea forms?
Yes.
Do you have any questions at all about anything on the written plea forms?
No, sir.
Are you currently under the influence of any medication, other types of drugs, or alcohol?
No, sir.
Are you thinking clearly at this time?
Yes.
Has any person coerced or forced you in any way to enter these pleas?
No, sir.
Has anyone promised you anything to get you to enter these pleas?
No, sir.
You understand that there is no plea agreement, and if you enter the pleas and the court accepts them, the sentence will be within the discretion of the court. You could receive any sentence from as little as time served up to a maximum of 27 years incarceration. Do you understand?
Yes, sir.
There would also be fine, court costs, driver's license suspension, and restitution if applicable. Do you understand that?
Yes.
I also heard there may be a probation case in Orange County.
That is correct, Your Honor.
If you were in fact on probation at the time any of these offenses to which you were pleading were committed, entering a plea in this case could provide proof that you did willfully violate your probation in the Orange County case. And so if you enter these pleas, and again, if one or more of these offenses occurred while you're on probation, without any additional evidence or proof, the court in Orange County could revoke and terminate your probation and sentence you to anything up to the maximum sentence that could have originally been imposed in your Orange County case. You understand, sir?
Yes, sir.
All right, you've been represented by Mr. Lopez in these cases. Are you fully satisfied with his representation of you?
Yes, sir.
You believe it is in your best interest to enter these pleas?
Yes.
You understand that if you are not a United States citizen, entering these pleas will subject you to deportation.
Yes, sir.
If you are sentenced to state prison in these cases or any other case, and if you've ever previously been convicted of a sexually motivated or sexually violent crime, once you complete any sentence the court might impose, you could be committed civilly for an indeterminate period of time as a sexually violent predator. Do you understand?
Yes.
You have the right in each of these two cases to have a jury trial to determine whether the state can prove that you committed these crimes. If you chose to go to trial, at each one of your trials, you would be presumed to be innocent. You could not be found guilty of any crime unless the state proved your guilt beyond to the exclusion of every reasonable doubt, and the jury unanimously agreed they had done so. You understand?
Yes.
You'd have the right at each of your trials to be represented by Mr. Lopez. You'd have the right to confront and cross-examine any witnesses who testified against you. You'd have the right to present witnesses and evidence in your defense at your trials. You are entitled to use of the court's subpoena power to require any witnesses you may have to be present at your trials. You also have the right at your trials to testify yourself, or you could choose not to testify. And if you chose not to testify, you have the right to have the jury instructed they could not consider the fact that you chose not to testify as evidence of guilt. You understand? By entering pleas of guilty, you're giving up each one of the rights that I've discussed with you, as well as the other rights that are written on the plea forms, and there will not be a trial in either case. You also, by entering these pleas, are waiving your right to appeal any matters relating to your cases other than this court's jurisdiction to hear the cases and the legality of any sentence the court might impose. Do you understand? All right, Mr. Mena, I find that you are alert and intelligent, that you understand the nature of the charges against you, the penalties that you're facing, as well as the rights that you're giving up by entering these pleas. I find that your decision to enter the pleas has been freely and voluntarily made, and that you've had the advice of competent counsel with whom you've expressed satisfaction. Excuse me, I've read the arrest affidavits by Deputy Gregory in case 20 CF 417 and by Deputy Cardenas in case 17 CF 4165. Based on those affidavits, I do find that there is a factual basis upon which your pleas can be accepted. So I'll accept your pleas of guilty. Mr. Lopez, do you agree with the score sheet 39-point total sentence?
Yes, Your Honor.
Is there any legal cause why we should not proceed to sentencing at this time?
At this time, Your Honor, no.
Is there anything further you or your client wish to say with respect to sentencing?
Your Honor, just to give the court a little bit of a background information on the possession case, which is the newer case, the 2020 CF 417, there was a plea offer extended of 90 days on that case. However, it was contingent on accepting a 10-month plea offer on 2017 CF 4165 case. Originally, there was a 6-month plea offer conveyed on that case, but due to the failure to appear, the state revoked that offer. I've been in extensive conversation with Ms. Mena's mother. She resides in Philadelphia. She unfortunately could not be here today. What's going on? But Mr. Mena does have the ability to return home. He does have employment waiting for him in Philadelphia. So he has a fresh start. He was 19 essentially when he picked up the cases out of 2017. He's never faced this much incarceration in his life. He just wants to resolve these cases. He's remorseful. He wants to resolve these cases and get to his new start, which luckily he has the opportunity with employment and a stable residence. I was just asking the court at this time to sentence him to 6 months on both cases.
What's the time served, Madam Clerk?
2017 CF 4165, 160 days. 2020 CF 417, 141 days.
Okay. Say anything with respect to sentence.
Yes, Your Honor, agreement is covering on behalf of Warren Day. The state did extend an offer. There was a voter resolution with GOP in Orange County as well. With that score sheet, he was scoring 2 months permanent corrections. He picked up another felony offense while out on probation. State extended a 10-month offer without the DOP going forward. At this point, the state is asking for a 10-month jail sentence and restitution of $500 for the victim.
All right, well, I will be ordering restitution. I don't know if the defense is in a position to agree to that amount or whether you can.
We weren't objecting to restitution again.
as to Juan Leopoldo Roman Santiago. All right. So, Mr. Mena, where'd you go for 2 years?
Here working,
I'm sorry?
working here.
You working here? Mr. Mena, I have to concede, I think the state's offer was a very reasonable offer, given the number and nature of the charges. In case 17 CF 4165, you'll be adjudged guilty of grand theft of a motor vehicle as charged in count 1, burglary of a conveyance as charged in count 2, conspiracy to commit burglary of a conveyance as charged in count 3, grand theft as charged in count 4, and contributing to delinquency or dependency of a minor as charged in count 5. As to each of those counts, you'll be sentenced to 10 months in the Osceola County Jail with credit for 160 days that you've already served. Those sentences will run concurrent with each other. You're ordered to pay court costs of $415, a $100 cost of prosecution, a fine of $500, restitution of $500 to Juan Leopoldo Roman Santiago. The restitution be joint settled with any co-defendant who may have been convicted of his part in the offenses. Were you retained or appointed, Mr. Lopez?
Retained, Your Honor.
You'll be required to submit to a biological, submit a biological specimen for inclusion in Florida Department of Law Enforcement DNA database. Let's take an oral swab from you at the jail. Your driving privileges are suspended for the period of this sentence pursuant to Florida Statute 322.274, I believe. Okay. You're ordered to pay the money that's owed in this case through the clerk's collection program at the rate of no less than $50 every month. You'll have until March 1st of 2021 to make your first payment, which will give you plenty of time to get out and get back on your feet. I'll make it April 1st of 2021. Just be sure that you are out, back home, and have time to find work and get on your feet. In case 20 CF 417, you'll be judged guilty of possession of cocaine as charged in count 1, and possession of drug paraphernalia as charged in count 2. As to each count, you'll be sentenced to 141 days in the Osceola County Jail, credit for 141 days time served. You're ordered to pay court costs of $415, a $100 cost of prosecution. There's a $15 court cost pursuant to Florida Statute 938.13, a fine of $250. Money's ordered to be paid through the clerk's collection program at the rate of no less than $50 every month, consecutive to the payments that were ordered in case 17 CF 4165. Your driving privileges are ordered suspended for a period of 6 months as required by law. The court has no objection to obtaining a business purposes license as soon as you may qualify. Is there anything further with respect to sentences?
I know, given the situation, Your Honor, is there any way to ask the court to have him transported to Orange? Or?
I'll indicate I have no objection to him being transported to Orange. I don't know what they're doing in that regard, Mr. Lopez. If you can reach a resolution of that case, we can resolve it down here.
Okay.
While he's in custody here. So, under the Supreme Court order, we have authority to do that. So, if you reach some resolution with the state up there, that's fine. We can schedule that here. If not, we can be transported up there.
Okay, thank you.
Mr. Bennett, you have 30 days within which you can appeal the judgments and sentences were just entered in your cases. If you want to appeal and you are unable to afford to hire a lawyer, I will appoint one to represent you. If you do not file an appeal in writing within 30 days of today's date, you waive your right to appeal. You understand, sir? Good luck to you. Thank you. Thank you, Mr. Lopez. I think that's all we have today. We're pretty busy tomorrow. Thank you. We recess until tomorrow morning at 8:30.